Division bench item 1, PIL Sumotu 1 oblique 2020.
Before my learned friend makes any submission, Lordship, at the outset, I would like to apologize because on the last occasion, it is me who insisted that the physical hearing is more preferable. But unfortunately, for the last 3 days, I was down and I'm physically weak to travel to Guwahati to attend the physical hearing. So I'm through virtual Lordships. So in that regard, I withdraw my submissions which I made on the last occasion for physical hearing.
Health issues nobody can predict. It's okay.
Obliged, Lordship.
Yes. Yes. So, Manoj, taking a cue from the last hearing with my Lord's permission, Manoj had indicated that Manoj, the petition would be heard on both Manoj, the maintainability issue and Manoj on the. So, if Manoj will permit me, Manoj, I have attempted to draw out a certain Manoj flow in which we can possibly Manoj approach the matter. And with my Lord's permission, I'll just articulate Manoj very quickly the manner in which I would like to seek my Lord's indulgence on Manoj.
Could you indicate the brief points and then elaborate?
Yes, I was just going to lay out exactly how it works, and then I'll start elaborating. So the first thing which will have to consider, and which is the big elephant in the room, is Article 131. Fortunately for us, there is a judgment of the Supreme Court, which has been pronounced only on the 10th of July, specifically on this issue, and I think that judgment really would be of great assistance, in possibly my Lord answering that question. So, Article 131 would be the first point, on maintainability, and I would request my Lords to consider that also for the reason that it is specifically mentioned in one of the orders. So, therefore, that issue must be put to rest. The second, Manoj, is also coming from an order of this Honorable Court, issue relating to the PIL jurisdiction, Manoj. Whether in a public interest litigation, whether, Manoj, in a public interest litigation, would it be possible for this court to consider the vires of an act and then, Manoj, take a decision on whether to quash it or to permit it? So, Manoj, those are the two issues which are there as far as maintainability is concerned. In my humble submission, we should be able to cover those. There should be no difficulty over there. And then, on the merits, the meat and potatoes of the matter, so to say, is the competence of the Naga Assembly. Twofold, the first, for them to stall an act of parliament insofar as its application to Nagaland is concerned. 371A would have to be considered for that. The other side of the coin, if the assembly were to decide to stall the application of an act of parliament, then does the competence to pass or enact laws on that particular issue transfer to the Naga Assembly? Is it inherent in the Naga Assembly? Or, Manoj, is there a vacuum which is created insofar as that stalling is concerned? That is something which my Lord will have to consider. And to that, Manoj, with the deepest respect, Manoj, my Lord will have to consider 371A, possibly also, Manoj, Chapter 11, Part 11 of the Constitution, Manoj, which is the grant of legislative power across the board, Manoj, to whichever is the legislative body, whether the parliament, Manoj, or the assembly, by the constitution, and Manoj, how it is worded and how the competence passes. That's Manoj, one part of it. The next part of
just a moment. While you address us on this scope and ambit of Article 131A, uh, please also consider example I am giving.
Yes,
My
sir.
examples are always horrible, but it's my impulsive habit to give horrible examples. Now you see, there is no dispute between the husband and the wife.
Loads.
Now a third party goes and says that no, you have a dispute. Because till date, the Union of India has not raised a dispute with regard to the power of the Assembly of the state of Nagaland to enact this particular act and rules.
Loads.
So now the scope of Article 131 A is that we can't touch it. We find elements there and we what you call wash off our hands. So that is the scope.
Yes.
Just a moment, Mr. Bhatagul. I'm sorry I got the news, but I couldn't make it. My condolences again.
Obliged.
Yes.
Yes, he lost his fathers for their a mother, father. So that's why,
So,
since I couldn't make it to his
Loads, that
place
very
to
kind
give
of
condolence, I'm doing it here. Yes.
So, Loads, I follow what falls from my loads, but to that extent, Loads, two aspects of that.
No, when you do your
Yes.
deliberation, then you can just address this. It's
Good.
not to answer immediately. You formulate your own answer and then
Yes.
place it.
Grateful, Loads, grateful.
Don't want you to dislodge you from your prepared argument. You just
Good.
go ahead.
Loads, I basically, Loads, since my Loads had said that the written submissions will come, Loads, at some point of time later, but not right at the beginning. So, Loads, I had just jotted down the points which I think, Loads, would cover all the aspects of the matter, Loads. So, Loads, the last point is going to be, Loads, the negative competence, Loads, on the scope of the negative competence of the Naga Assembly. And Manoj, whether in that part, Manoj, which is 371A, 1A, 1 to 4, and in 4, Manoj, the phrase that is used, Manoj, is ownership and transfer of land and its resources. So, Manoj, on the one side, we have ownership and transfer, and on the other side, we have land and its resources. Now, Manoj, what would be the contours of ownership and transfer versus regulation, which is what the Oil Fields Act attempts to do. That part, my Lord, will have to consider, and again, we have the benefit of the 9-judge bench judgment now. Where this aspect has been quite broadly elucidated, versus land and its resources. On in fact, it was a little bit of a surprise for me also. On who will be the proprietor of the minerals on the land and below the land? That also. We may not need that today, because we may not need that today, because when we go through, I will be taking some time, so may not need those petroleum acts today. But look, what I was surprised about is that this question has attracted the attention of the Supreme Court, and even in the acts, the MMD, the Mines and Mineral Development and Regulation Act, and in the Oil Fields Act also, is quite well acknowledged, that it is not always the government which is the owner of the minerals. It is quite possible, in the Indian scheme of things, that the minerals may be owned on the land by a private party. And therefore, how that private party goes ahead and then exploits those minerals is also all provided for. So that part also will consider on where the competence with that respect lies. And
this point has to be examined in the light of submissions made by Mr. Zamir.
Yes.
Giving the historical background and then saying that Article 371A, this implication he has explained to a great extent.
Yes. Now, my lords, over there again, I mean, not to digress, my lords, but again, over there, my lords will then have to also view in terms of the three lists on, my lords, how the competence with respect to land is, my lords, not just bifurcated, but possibly, my lords, trifurcated, and in 4 or 5 or 6 entries across the 7th schedule, it is, my lords, across the lists. So, my lords, while oil is in entry 53, list 1, my lords, mines and mineral is in 54, and list 2 23. Similarly, below the agriculture is 14, but land and below the transfer of agricultural land in 18 in list 2. And then there are entries in list 3, which again relate to land. So land by itself is variously distributed. The legislative competence with respect to land is variously, and the resources is variously distributed across the 3 lists. So when the Union Act is stalled, then whether the competence automatically shifts to the Naga Assembly, or it creates a vacuum, or it was always inhering in the Naga Assembly. That those are the aspects which will have to then consider, and they'll be, in my humble submission, it seems that there is a possible harmonious construction possible on keeping in view 371A and the constitutional structure of how it could work out. But I will present our side of it, and my lords will of course then consider it. Now, in so far as 131 is concerned, straight away coming to that point, which is on the maintainability of the issue. If we'll have Article 131 for a moment. My lords are with me? You can lords, permission lords. 131, original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, this would be important, subject to the provisions of the Constitution, the Supreme Court shall, this is also important, to the exclusion of any other court, original jurisdiction in any dispute, and then the nature of the dispute is said between the government of India and one or more states. B, between the government of India and any state or states on one side and one or more states on the other. So there could be supporting states and there could be dissenting states, and the government of India would be in the middle. And C, between 2 or more states. Now, A, B, and C, in my humble submission, define who can be the parties to a dispute envisaged in 131. And then the last part of it, it says, if and in so far as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. I just take a minute just to break this down for a minute. So it says the dispute must involve a question of law or fact. That part is taken care of, on which the existence or extent. So the existence also, and if the existence is acknowledged, then the extent of a legal right depends. Why I say that is because the early days in the 60s, in the state of Bihar versus Union of India judgment, which we just go through presently, a constitution bench had said that the question which is envisaged here is not really just a random everyday question. This has to be a question because of the parties involved, something which has to do with the federal structure of the state or the entire union. So if it is a question which relates to the federal structure, then it is something which is covered in 131. Now, later on in a 7-judge bench judgment, the Supreme Court again revisited the issue and really discarded that limited, narrow viewpoint and said it could be any right. As long as there is a legal right which is being asserted, that is enough. It doesn't really need to relate to the federal structure, but it can be to any dispute, any question. So, there are 3 points which come out of this article, which must be satisfied before this court will hold its hand. The dispute must be, then we are really covered with A, so I won't bother my lords with B or C. The dispute must be between the government of India and one or more states. So, this clause really doesn't broker any other private party in the dispute. So, if a private party is involved, what will be the consequences of that? Or would that be a dispute which will fall only in 131A to the exclusion of all other courts? Or the existence or the necessity of a private party, as in this case, would negate the entire argument of 131, and this will be a normal thing which can be adjudicated to the extent of maybe some competing rights between the union and the state. But because there's a third party involved, therefore it will be a 226 jurisdiction and the court can proceed with it. That's one part, one question which will arise. The second part would be the question that is presented, whether it's a...
No, but you see, it is a question which has to be determined, not a dispute between the parties to a lease. So that is a distinguishing factor.
Yeah.
Because if it is a law which is required to be answered, then private parties or any other corporation, they are not necessary parties, because essentially it is you are trying to establish two things with your wordings. You said that negative clause.
Yes.
And so therefore it is only that part which requires to be answered.
Yes.
So why would we say that there is a private party to a dispute?
Yes. So exactly on these lines, in fact, the judgment that I'm going to read dealt with it extensively. And that judgment is the state of West Bengal latest and versus the Union pronounced only on the 10th of July, which related to would recall that the CBI under the Delhi Police Special Enactment has a overall all India jurisdiction, provided a state issues a notification saying that yes, they can come and do it. Would recall Bengal had given that in 89, that notification was there. And then in the recent years, they had withdrawn that notification. Whether after the withdrawal, the government would have, the union could, or the CBI could proceed with some cases or not, is the question. And there is a civil suit which is filed by the state of West Bengal before the Supreme Court. And this 131 question came up there. And it dealt with specifically keeping in the earlier 2 judgments of Bihar and Rajasthan in mind. And this particular question specifically on whether a private party is allowed or not has been dealt with. And where they've specifically said, I just take my through those relevant paragraphs. Extensively they've dealt with it, and they've said that the moment there is a private party, then as in this case, we'll see the question of the PNG rules, the Naga PNG rules, comes in view of the permit which has been issued. Now, there is a beneficiary over there of the permit, which is the private party. And that is specifically what the Supreme Court has said, that as soon as there is a third party involved, this really is just another question of competence, which the High Court can take care of. Because if the Naga rules are there, and whether they are within the domain of the assembly or not, this is a question which is more the regular 226 question. It doesn't really require a 131 jurisdiction to the exclusion of all other courts that nobody else can look at it. So it's not that. And then the second part they've dealt with is the nature of the question. And where again, they've said that it could be any, it doesn't have to be, the question doesn't have to relate to the federal structure of the polity, but it can be a question where a legal right is asserted, and therefore it is done. May I straight away invite my lord's attention to this judgment, the state of West Bengal versus Union of India. No, I'm just. Loads would have access to load the SCC or online SCC. They've gone to take a printout. No, they'll just take a minute. In fact, Manoj, in that case, the court thought it fit and proper to first deal with this 131 issue. So that order specifically relates only to the maintainability issue, which was, Manoj, the challenge was negative. And Manoj, the court held that yes, 131 would not fall in the way, that the jurisdiction would be 131.
Yes.
Manoj, have that? Manoj, this is the state of West Bengal versus Union of India, Manoj. Yes. So, Manoj, may I just straight away invite my Lord's attention to, Manoj, in para 1, the reliefs are stated. And Manoj, please see para 2. On filing of the suit, preliminary objection has been raised by the defendant Union of India with regard to the maintainability of the present suit. Through this judgment, we have dealt with the contention of parties on the aspect of maintainability. That's all notes that it does. We'll see. Para 4 submissions of the defendant. The basic objection with regard to tenability of the suit is based on Article 131 of the Constitution, for short, the Constitution. And then it goes on to articulate. May I just read that note? The learned SG submitted that upon interpretation of 131 of the Constitution, it is clear that the provisions of 131 of the Constitution are subject to other provisions of the Constitution. Note the beginning word, subject to the other provisions of the Constitution. He therefore submitted that since the issue involved in the present case is also an issue arising in certain appeals pending before this court under 136, a fresh suit under 131 would not be tenable. It is submitted that the term subject to the provisions of this Constitution has to be interpreted as subject to the other provisions of the Constitution, including Article 136. It is therefore submitted that since the issue with regard to the same subject matter is pending before this court under 136, a suit for the same purpose in 131 is barred. And look, similar argument taken for 226 also, that 226 also is a provision of the Constitution and therefore it will be. Look, para 6 is where they really articulated just that way, while making a reference to the term subject to the provisions of this Constitution of Article 131 of the Constitution. The learned SG submitted that since the subject matter of the present suit is also pending before the court or the high courts under Article 136 or 226 of the Constitution respectively, the present suit would not be tenable. may have then para 22, which is the legal framework when the court once started submitting. May I also submit that one of the arguments which was taken was that there is no cause of action. And which is why the Supreme Court rules were referred to. I'm not going to bother my lords with that. That doesn't really concern us over here, whether there is a cause of action or not. That part was limited only to that. May have para 30. Article 131 of the Constitution. Yes. It would be apposite to refer to Article 131 of the Constitution, which reads thus. They've done that. And para 31, we've gone through the article already, so I'm not bothering my lords again. It is thus clear that the jurisdiction of this court, subject to the provisions of the Constitution, is to the exclusion of any other court. That's to the exclusion part. The jurisdiction has to be exercised for any dispute either between the government of India and one or more states, or between the government of India and any state or states on one side, one or more states on the other, or between the two states. The jurisdiction is also limited insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of the legal right depends. Now, there are two judgments, which are, as I said, of a constitution bench and then a 7-judge bench. The first one is State of Bihar, which really laid down the groundwork for this. The learned Solicitor General relied on the constitution bench judgment of this court in the case of State of Bihar. In the said case, the State of Bihar had filed 9 suits against the Union of India, who was the first defendant in all of the said suits. Whereas in 6 suits, the second defendant was Hindustan Steel Limited. And in others, the second defendant was Indian Iron and Steel. In the other 3 suits, the second defendant was the Indian Iron and Steel Company Limited. The cause of action in all the said suit was that due to the negligence or deliberate action of the servants of both defendants, there was a shortage in the delivery of iron and steel material ordered by the plaintiff to various sites in the state of Bihar in connection with the construction work of the Gandak project. It will be relevant to refer to the following observations made in the said judgment. With the deepest respect, while the quotations are all relevant, the most important are the highlighted portions. So, but it's only 3 or 4 paragraphs. I'm so grateful. Clauses A, B, and C of the article specify the parties who can appear as disputants before this court. Under Clause A, it is the Government of India and one or more states. Under Clause B, it is the Government of India and one or more states on the one side, and one or more other states on the other. While under Clause C, the parties can be 2 or more states without the Government of India being involved in the dispute. The specification of the parties is not of an inclusive kind. The express words of clauses A, B, and C exclude the idea of a private citizen, a firm, or a corporation figuring as disputant either alone or even along with the state or with the government of India in the category of a party to the dispute. There is no scope for suggesting that a private citizen, a firm, or a corporation can be arrayed as a party by itself on one side and one or more states, including the government of India on the other. Nor is there anything in the article which suggests a claim being made by or preferred against a private party jointly or in the alternative with the state or the government of India. The framers of the Constitution appear not to have contemplated the case of a dispute in which a private citizen, a firm, or a corporation is in any way involved as a fit subject for adjudication by this court under the exclusive original jurisdiction conferred by Article 131. So far as the proceedings of the Joint Committee on Indian Constitutional Reform and the report of the committee on the same are concerned, they make it clear that the object of conferring exclusive original jurisdiction on the federal court was that the disputes of the kind specified between the federation and the provinces as the constituent units of the federation should not be left to be decided by courts of law of a particular unit, but be adjudicated upon only by the highest tribunal in the land, which would be beyond the influence of any one constituent unit. Although Article 131 does not define the scope of the disputes with which this court may be called upon to determine, in the same way as Section 204 of the Government of India Act, and we do not find it necessary to do this much, is certain that the legal right which is the subject of dispute must arise in the context of the constitution and the federalism it sets up. This is the part which came to be questioned in the 7-judge bench. This particular sentence, we do not find it necessary to do so. So this much is certain, that the legal right which is the subject of dispute must arise in the context of the constitution and the federalism it set up. This sentence was questioned in the 7-judge bench. However, there can be no doubt that so far as the parties to the dispute are concerned, the framers of the constitution did intend that they could only be the constituent units of the Union of India, and the Government of India itself arrayed on one side and or the other, either singly or jointly with reference with another unit or the Government of India. It was argued by counsel on behalf of the state of Bihar that so far as the Hindustan Steel Limited is concerned, it is state. And the suits in which the Government of India, along with Hindustan Steel Limited, has been pleaded are properly filed within 131 of the Constitution, tribal by that court in its original jurisdiction. Reference was made to the case of Rajasthan State Electricity Board. There, the question arose between certain persons who were permanent employees of the government of the state of Rajasthan and later placed at the disposal of the State Electricity Board. And one of the questions was whether the appellate board would be held to be state under 12. This court by a majority held that the board was other authority within the meaning of Article 12 and therefore was a state to which appropriate directions could be given under Article 226 and 7 of the Constitution. It will be noted that under Article 12, all local and other authorities within the territory of India or under the control of the Government of India are state for purposes of Part 3, which defines and deals with the fundamental rights enshrined in the Constitution. The expression the state has the same meaning in Part 4 of the Constitution under Article 36. No reason was shown as to why the enlarged definition of state given in Part 3 and 4 would be attracted to 131 of the Constitution. And in our opinion, a body like Hindustan Steel cannot be considered to be a state for the purpose of 131. So even body corporates which are fully owned by the government are also out. They are private parties as far as 131 is concerned and can't be done. It would be seen that this court held that the express words of ABC of Article 31 of the Constitution exclude the idea of a private citizen, firm or corporation figuring as a disputant, either alone or even along with the state or the Government of India in the category of a party to the dispute. It has been held that the framers of the Constitution did not contemplate a dispute in which a private citizen, a firm or a corporation in any way involved as a fit subject for adjudication by this court under its exclusive jurisdiction under 131. It further observed that the legal right which is the subject of dispute must arise in the context of the Constitution and the federalism it sets up. It has been unequivocally held that there can be no doubt that so far as the parties to the dispute are concerned, the framers of the Constitution did not intend that they could only be the constituent units of the Union of India, and the Government of India itself arrayed as on one side or the other, either singly or jointly, with another unit. The court then observed under Article 12, that part we've been through it, that it's not state and will not be covered under 131. Now, the 7-judge bench judgment, which is the state of Rajasthan. Yeah. The learned Solicitor General strongly relies on the judgment of this court in the case of State of Rajasthan and others, Union of India. The brief facts in the said case are elections held in March. This is quite interesting. You know, I was not much too young at that time, but when I read this, it was quite interesting. In the elections held in March 77, the Janata Party had secured overwhelming majority in the Lok Sabha. In some of the states, the Congress was continuing in power. In view of the complete and unequivocal rejection of the Congress party, the Union Home Minister addressed a communication on 18th April to 9 states, asking them to advise their respective governors to dissolve the assemblies. You know, this is not good. I mean, no, I know West Bengal.
My lord, a copy may be given to us as read out, because we are not certain.
Within due course.
It's quite interesting. You win an election and you write to the opposition ruled state that you advise the governor to dissolve yourselves. That's a yes. May I continue? Says the Union Home Minister addressed a communication on 18th April to 9 states, asking them to advise.
Since I have this, you can use this in written email.
No, we've given them a copy.
Oh, it's okay.
Given a
Because we have this.
Oh, the
facility,
iPad.
so therefore.
The iPad is superbly convenient, especially for the markings and everything. It's very, very convenient. Addressed a communication on 18th April to the 9 states, asking them to advise their respective governors to dissolve the assemblies and seek a fresh mandate from the people. Some of the states had filed suits before the Supreme Court, praying for a declaration that the letter of the Union Home Minister was illegal and ultra vires of the Constitution of India and not binding on the plaintiff, and prayed for an interim injunction restraining the central governments from resorting to Article 356 of the Constitution. Preliminary objections were raised on behalf of the defendant, Union of India, against the maintainability of the suits under 131 of the Constitution. The preliminary objections were raised on 2 grounds. The first was that Article 131 of the Constitution of India, the state and not the state government should be a party. The second was that the present matter did not involve a legal dispute, really was a political dispute. One other aspect which came up over here is the scope of the power of the Supreme Court while issuing an order in 131. Could it also include to complete relief, give injunction orders, mandatory or injuncting otherwise, but or not? That also came up. It will be apposite to refer to the following paragraphs of the judgment of Y.V. Chandrachud, Justice Y.V. Chandrachud, as his lordship then was. The absence of the expression state government and the use in its place of the expression state in Article 131 is said to furnish intrinsic evidence that for a suit to fall under this article, the dispute must arise between the government of India and a state, not between the government of India and the government of a state. The intrinsic evidence, it is argued, assumes greater credibility in the context that the article does employ the expression government of India when what was meant was the government, as contradistinguished from the state, The presence of the particular expression in 131 does not, in my opinion, support the inference suggested on behalf of the Union of India. The use of the phrase Government of India in Article 131A and B does not mean that one party to the dispute has to be the government of the day at the center. Government of India means Union of India, because it will be, if there be merit in the logic that Article 131 does not contemplate disputes in which the government of a state, as contrasted with the state itself, is interested, it must follow that correspondingly the government of India too cannot mean the government for the time being in power at the center. The true construction of Article 131A, true in substance and true pragmatically, is that a dispute must arise between the Union of India and a state. This may sound paradoxical, because if the preliminary objection is unsustainable, it would be easier to say that the expression Government of India means government in office, and the expression state means the state as a polity and not the government in office. But convenient interpretations are apt to blur the significance of issues involved for interpretations. Therefore, the effort has to be to accept that what the words truly mean and to work out the constitutional scheme as it may reasonably be assumed to have been conceived. Notes why I read this is because I will come back to this note when we are interpreting 171A. Over there also, similarly, we'll have to look at it in pragmatically, how it goes. The dispute between the Union of India and a state cannot but be a dispute which arises out of the difference between the government in office or at the center and the government in office in state. In office means in power, but the use of the latter expression may prudently be avoided with the realization of what goes with power. But there is a further prerequisite which narrows down the ambit of class of disputes which fall within Article 131. That requirement is that the dispute must involve a question, whether of law or fact, on which the existence or extent of a legal right depends. It is this qualification which affords a true guide for determining whether a particular dispute is comprehended under Article 131. Mere wrangles between governments have no place in the scheme of that article. They have to be resolved elsewhere and by means less solemn and sacrosanct than a court proceeding. The purpose of Article 131 is to afford a forum for the resolution of disputes which depend for their decision on the existence or extent of a legal right. It is only when a legal, not a mere political issue arises, touching upon the existence or extent of a legal right, that Article 131 is attractive. I find it difficult to accept that the state as a polity is not entitled to raise a dispute of this nature. In a federation, whether classical or quasi-classical, the states are vitally interested in the definition of the powers of the federal government on the one hand and their own on the other. A dispute bearing upon the delineation of these powers is precisely the one in which the federating states, no less than the federal government itself, are interested. I'll pause here for a moment. This really answers the question, whether the question raised in the present matter is covered under 131 on. Because with my Lord's permission, it says clearly, in a federation, whether classical or quasi-classical, states are vitally interested in the definition of the powers of the federal government on the one hand and their own on the other. A dispute bearing upon the delineation of these powers is precisely the one in which the federating states, no less than the federal government itself, are interested. So, the question these petitions raise is squarely covered in 131. The states, therefore, have the locus and the interest to contest and seek an adjudication of the claims set up by the Union government. The bond of constitutional obligation between the government of India and the states sustains the locus. The expression legal right, which occurs in Article 131, has to be understood in its proper perspective. In a strict sense, legal rights are correlative to legal duties and are defined as interest which the law protects by imposing corresponding duty on others. But in a generic sense, the word right is used to mean an immunity from the legal power of another. Immunity is exemption from the power of another in the same way as liberty is exemption from the right of another. Immunity, in short, is no subjugation. Then someone says, Dyer says in his jurisprudence that the word right has undergone successive shifts in meaning and connotes four different ideas concerning the activity or potential activity of one person with reference to the another. One of the four juror relationships, according to the learned author, is the you cannot relationship, which is the same thing as the right to immunity, which denotes freedom from the power of another. Patton's book contains a similar exposition of legal rights. The legal right of the states consists in their immunity in the sense of freedom from the power of the union government. They are entitled under 131 to assert that right either by contending in the absolution that the center has no power to dissolve the legislative assemblies, or with the qualification that such a power cannot be exercised on the ground stated. Aside of this, I'll just pause again for a moment over here. So, just pausing here for a moment, this is this concept of immunity, from the you cannot rule, so to say, is classically the question involved here. There is a Union Act. The state of Nagaland says that no, you cannot impose this in the state of Nagaland unless I pass a legislative assembly resolution permitting its application or accepting. No, I'm so sorry for using the word permitting, accepting its application in Nagaland. So, the immunity or the right which the Naga assembly has is to assert that your act will not apply unless my acceptance is there. So, this is classically the question which the Supreme Court says is covered under 131. My difficulty that there is a private party and therefore I'm non-suited remains. Because even in this judgment, as we read further, they say that if there is a private party involved, that's it. You can't go to 131. But if the Naga government has an issue with the Oil Fields Act, for instance, and they say that no, this is not going to get applied here, then 131 is their remedy, where they can go to the Supreme Court and say that I have the power under 131, I have the defensive, so to say, privilege under 171A to stall the application, and I need a protection over there. Alternatively, the act would apply. Yes. So, if will have para 115 goes on to say, it is true that the state, like the British monarch, never dies. A legislative assembly may be dissolved, a council of ministers may go out of power, the president rule may be introduced or imposed, or an emergency may be declared, which can conceivably affect the state's power in matters legislative and executive. The state survives these upheavals, but it is constitutionally unsound to say that the state as a political entity has no legal interest in such cataclysmic events and no legal rights to assert in relation thereto, where it is so, which has been, which then are the legal rights which the state, as distinguished from the government, can agitate under 131. Whatever be the nature of the claim, the argument can always be put forward that the government, not the state, is interested in making that claim. Such a rigid interpretation of the scope of 131 will virtually reduce it to dead letter and destroy a precious safeguard against the use of arbitrary power. Interpretation canvassed by the learned additional Solicitor General must therefore be avoided. Insofar as the language of the article permits it, which in my opinion it does. Now, they deal with that part of the Bihar judgment. Just one paragraph. The judgment of this court in state of Bihar affords no real assistance on the question arising before us. In that case, the court raised three issues in the suits filed under 131. The first issue, which related to the question whether the suits are within the scope of 131, was not answered by the court because it held on the second issue that the suits are not maintainable since a private party was impleted thereto. The only assistance which may be derived from the judgment in that case is that it said that the disputes under 131 should be in respect of legal rights and not disputes of a political character. And that though it was unnecessary to define the scope of Article 131, this much is certain that the legal right, which is the subject of dispute, must arise in the context of the Constitution and the federalism it sets up. These observations do not affect the construction which I have placed on 131. I have endeavored to show that it is competent to the state government to bring suits of the present nature under that article, and that by these suits, the state government are raising a legal, not a political issue. Their assertion is that the government of India does not possess the constitutional power claimed by it, and therefore this court should declare that they are immune from the exercise of that power. The states assert their legal right of immunity, which, as explained above, denotes freedom from the power of another. It would thus be seen that Justice Chandrachud observed that the true construction of 131A, true in substance and true pragmatically, is that a dispute must arise between the Union of India and a state. His lordship further observed that the dispute between the Union and a state cannot but be a dispute which arises out of the differences between the government in office at the center and the government in office in the state. It was further held that the further requirement for a dispute to fall within the ambit of classes of disputes under 131 is that the dispute must involve a question whether a fact of law on which the existence or extent of a right depends. It was further observed that mere wrangles between the government have no place in the scheme of the article. Lordship further held that for the purpose of 131 is to afford a forum for the resolution of disputes which depend on their decision to the extent of a legal right. It has been held that it's only when a legal, not a mere political issue arises upon the existence or extent of a legal right, 131 be there. Specifically rejected the contention the state as a polity was not entitled to raise a dispute. Now, Mloz will come to para 39. That's the next Mloz. Para 39, Mloz, where the quotation again starts. Further observe, this takes us to the maintainability, to the question of maintainability of the suit. There are 6 suits filed before us, filed by the states of Rajasthan, Madhya Pradesh, so and so, each of the units, so and so. 131 is quoted, and after the quotation, there are 2 limitations. I'm not reading the quotation, we've gone through 131 already. There are 2 limitations in regard to the nature of the suit which can be entertained by the Supreme Court under this article. One is in regard to parties and the other is in regard to the subject matter. The article provides in so many terms in clauses A, B, and C that the dispute must be between the government of India and one or more states, or between the government of India or any other state or states on the one side and one or other states on the other, or between 2 states. It does not contemplate any private party being arrayed as a disputant on one side or the other. The parties to the dispute must fall within one or the other categories specified in clause A, B, and C. This was established by a decision of this court in the state of Bihar, where the court pointed out. That quotation we've read already in notes. This is the limitation as to parties. The other limitation as to subject matter flows from the words insofar as the disputes involve any question, whether legal, whether of law or fact, on which the existence or extent of a legal right depends. These words clearly indicate that the dispute must be one relating to a legal right and not to a dispute on the political plans, not based on a legal right. For instance, To take an example given by Mr. Sirvai in his well-known work, Constitutional Law of India, a claim that a state project should be included in the 5-year plan. This dispute must therefore involve assertion or vindication of a legal right of the government of India or a state. It is not necessary that the right must be a constitutional right. All that it is necessary is that it is a legal right. It is true that in the state of Bihar versus Union of India, this court, while discussing the scope of the dispute, which may be determined by the Supreme Court under this article, under Article 131, happened to make an observation that this much is certain, that the legal right, which is the subject of dispute, must arise in the context of the Constitution and the federalism it sets up. But this observation, insofar as it suggests that the legal right must be one which arises under the Constitution, goes much further than what the language of 131 warrants. This is where, Manoj, they distinguish it. The article speaks only of legal right and does not qualify it by any other words. It may be noted that the provision in the corresponding section 204 of the Government of India Act was significantly different. It contained a proviso that the dispute must inter alia concern the interpretation of the Government of India Act or of an order in council made thereunder, or the extent of the legislative or executive authority vested by the federation by virtue of the instrument of accession of that state. This provision has been deliberately and decidedly omitted in Article 131, and now any legal right can be enforced by a suit in the Supreme Court, provided the parties fill the character specified in clause A, B, and C. The question which therefore requires to be considered in determining the maintainability of the suit is whether any legal right of the state is sought to be vindicated in the suits. We shall presently consider this question, but before we do so, we must point out one other error in which, with the greatest respect, the learned judges who decided state of Bihar seem to have fallen. They held that the suit under 131, this is on the power of only declaration or injunction. It may not be so relevant to us over here. It's para 40. It could thus be seen that His Lordship approved the ratio in state of Bihar to the effect that the suit under 131 of the Constitution does not contemplate any private party being arrayed as a disputant on one side or the other. It held that the parties to the dispute must fall within one or the other category specified in A, B, or C of the article. So, that's as far as the parties are concerned. And 41, Lordship disapproved the observation made by in the case of state of Bihar to the effect that this much is certain, that the legal right, which is the subject matter of dispute, must arise in the context of the Constitution and the federalism it sets up. His Lordship held that the suggestion that the legal right must be one which arises under the Constitution goes much further than the language of 131 warrants. Then, Lords, they discussed 204. In para 43, in the light of the law laid down in the case of state of Rajasthan, which is the judgment of 7 judges of this court, we have to examine the rival submissions. And then, of course, they go on to consider on the merits of it, on whether the question is raised or not raised. But as far as 131 is concerned, we'll have the conclusions at para 84. Where they reject the challenge and proceed with the suit. Now, therefore, by way of this judgment, one thing which comes clearly, even by the state of Rajasthan, which is the benchmark judgment. So 131 to be applicable, two things have to be. The first is that the parties have to stricto sensu be what is given in A, B, or C. nobody else can come in that jurisdiction. Even Lord periphery. So Lord, even if your respondent 7, as in this case, which possibly is not what is contemplated in 131. The second part is that the question which must be is a contest between the federal and the provincial government, the union and the state, relating to their legislative or executive powers relating to a subject matter. Now, in that question, as far as the second aspect is concerned, in my very humble submission, we satisfy. And 131 would be applicable, but the whole thing, since we don't satisfy the party angle, I'd leave it to my lords whether the private party has such a role to play, because the challenge in the writ petition is relating to the PNG rules, whether they are valid or not valid. That's the question. Of course, once that decision is taken, the permit, whether it survives or not, and whether respondent 7 being the beneficiary of that permit will have any rights or those rights get extinguished, is a question which is a sequitur and consequently will follow. But as far as presently in the manner in which the writ petition is framed, 131 requires that it can only be the state or the union. The union may choose to make a presidential reference or file a 131 suit, or the state may go ahead and file a 131 specifically on this question relating to the Naga rules. That's not what we are dealing with here right now. There is a writ petition, private parties are involved, and the judgment is there in front of us. Now coming to the second aspect, that's my submission on 131 on the maintainability issue. The second aspect, if will oblige me by just please viewing the order dated 14th of February 24. That is when the second issue of maintainability was articulated.
Order dated 14?
14th of February 23.
Yes.
We'll have the third page of the order, which starts with in the course of deliberation. The first page is just the parties. In the course of deliberations, taking note of the order of 4th of August 2022, two questions of the court are as follows. A, whether in the light of Article 371A(1)(a)(4) of the Constitution of India, in the absence of any resolution of the Legislative Assembly of Nagaland, the government of Nagaland would have the legislative competence to frame the Naga PNG regulations and Naga PNG rules. That I'll deal with in a bit. The B part is important right now, where it says whether in a PIL it would be appropriate to quash and set aside the said 2012 regulations and 2012 rules on account of lack of legislative competence. I'm dealing with the part B of it right now, so that we are covered with the maintainability issue once and for all. So, this really relates to the jurisdiction of a code, the constitutional code, such as, the one which one nodes are, nodes. See? Now, I'm only on this part on the jurisdiction in a public interest litigation. And whether, it is possible for this honorable court to consider the vires of any act, rules, or regulations in a public interest litigation, and then decide. My humble, my submission is that yes, this court has the jurisdiction. There's no and I'll make good that submission. And that will be in two parts. The first is the contours of a PIL 226 and what is the jurisdiction my lords exercise over there. The second whether this really is more in the nature of a PIL or more in the nature of a representative petition. Because the petition was originally filed, if would recall, by the ho-ho of a particular jurisdiction. Then it came to be withdrawn, and then the petition that was filed presently is by the Lotha ho. And that also after much deliberation. Many resolutions which have been passed, many consultations which have happened, and only then an authority has been given to go ahead and file. So this is, in my very humble submission, my lords will have to consider whether this is just a public interest litigation or is it a public representative interest litigation. In my humble submission from the reading laws, as I see it, it appears to be more in the nature of a representative petition that where it represents a larger interest of the Naga people. It definitely is not the cautionary note which has been sounded by many courts, including possibly this court also that public interest litigations many ways slide into publicity interest litigation. This is definitely not that. There is a real contest over here between the application of the act, and therefore it is in that jurisdiction. To that extent, if will have the Guru Vayur Devaswam board judgment which was handed over last time, I wonder if will still have it.
Yes.
May I just very quickly point out just what the dispute over there was, which was more intricate actually. If we'll just have the introductory remarks para 2 and 3. We lay out the background and then what the orders of the court came to be passed. Introductory remarks. Sri Krishna Temple, Guruvayur, draws millions of people from all over the country. This ancient temple of unique importance is worshipped and held in great reverence by lakhs of devotees. The temple owns extensive movable and immovable properties and endowments. It has its own heritage and traditions. The state of Kerala, having regard to the importance of the said temple, with a view to make suitable provisions for the proper administration of the Guruvayur Devaswam, enacted the Guruvayur Devaswam Act. The management of the temple is carried out in terms of the provisions of the Act. So, the temple is there, the Act is there, and then the relevant provisions of the statute, I won't bother my lords with. Extensive. There's a governing committee, how they are to do, what are the reports they have to file, everything, how the state interacts with them, everything taken care of. Now, may straight away come to para 7. The genesis of the public interest litigation, if Lord will have. This is where the maintainability issue arose. Para 7, and just above that, genesis of the public interest litigation. One Shri C.K. Rajan addressed a letter dated 3/2/93 to one of the Honorable Judges of the High Court of Kerala, thereby bringing to his notice purported serious irregularities, corrupt practices, maladministration, and mismanagement prevailing in the temple. He was called by the High Court, and its registrar recorded his statement on 11/2/1993. The said letter was treated as an original petition under 226. The High Court, in its order dated 12/2/1993, highlighted 23 aspects of the matter which had been brought to its notice and appointed one Shri Krishnanunni, District Judge, officiating as the Director of Training, High Court of Kerala, as the Commissioner to make a general inquiry and in particular make a study on the various aspects highlighted in the said complaint. The Commissioner, pursuant to the order of the High Court, seized all the records of the temple, examined 85 witnesses, and submitted as many as 15 interim reports. One of the grievances is that he didn't have search and seizure powers. The other grievance is that the 85 witnesses, no cross-examination allowed. Their word was taken as gospel truth, and orders were being passed. And of course, the 15 interim reports, no objections were filed by either side because nobody wanted to acknowledge the reports. So that's the circumstances in which the power of the High Court in a PIL jurisdiction to appoint a commissioner, grant search and seizure powers, and then to cross-examine or set up a process where orders were issued by the High Court pursuant to the committee reports, and the state government was given recommendations, some of which were accepted by the state government. That's the circumstance under which the contours of the jurisdiction came to be decided. My Lord Justice Sinha, in his typical succinct manner, para 50, if will have now, is where my Lord articulates the principles evolved by the Honorable Supreme Court in behalf suitably summarized. Oh, I'll give it to you. And मैं दे देता हूँ जी 2003 7 SCC 546. Thank you. The 2003 7 SCC.
This says it cannot be done. This says it cannot be done.
No, it can be done.
It can be done.
It can be done. If we'll have para 50, there is a cautionary note that you have to be careful when you're looking at the vices of an act. That there have to be some real dispute.
No, I am on that part of the commissioner and the
Yes.
High Court to have witnesses recorded and then take their reports and then to act upon it.
Yes.
What was the
The
decision
finding
there?
over there is that too much time has passed and therefore we let it be. So time, as they say, is the greatest warrior. Everybody will lose to time. Even litigation, those parties will also lose to time.
I was digressing a little and recollecting the manner of proceedings in the TN Godavarman.
Yes, the forest matter. Yes, yes, yes. Similarly, yes.
Because the Supreme Court took the aid of the environmentalists and the this MC Mehta.
Yes,
Those things were taken up and then the court proceeded on the environmental litigation.
yes.
That is how it was developed.
That's how it was developed, but that was an extraordinary, and that set
that's
out the
okay.
benchmark actually for the future also.
No, that's okay, but I'm just digressing, so I'm just seeing it,
From
if
that
you are
perspective.
reconcilable or not.
Because in fact, in Godavar Raman laws, one salutary thing was that the court got every state to define what will be a forest. Some laws that while in Delhi, I know laws where we have that the rule is that if you have more than 100 trees per acre and the portion of the land is about 2.5 acres, it's a forest. But you need to have 100 trees per acre. That's the thing. Simlo, which is quite a dense thing. If one were to Simlo, then acre is 4,000 square meters. And if you have 100 trees, it's almost like every 40 square meters, you must have a tree. So that's fair. All right. But every other state then has its own loads criteria. Like I understand loads, Assam has a much wider definition because today in the morning, I was just looking outside the balcony and it was green. It was very green. Very pleasantly so much. We don't get that benefit, but very green. If not, will have para 50. The principle evolved by this court in this behalf may be suitably summarized as under. The court in exercise of powers under 32 or 226 of the Constitution of India can entertain a petition filed by any interested person in the welfare of the people who is in a disadvantaged position and thus not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental rights of such disadvantaged people so as to direct the state to fulfill its constitutional promise. The side of the fact that I appear for the Union of India, I believe in one, this petition is covered. Because if Manoj were to see, this is Manoj the Lotha Hoho, the Naga people asserting their right in 371A and was knocking the doors of this court. I really was, despite the fact that I appear for the union, I really don't know how to oppose that. If Manoj were to have two issues of public importance, enforcement of fundamental rights of a large number of public versus the constitutional duties and functions of the state, if raised, the court treats a letter or a telegram as a public interest litigation upon relaxing procedural laws as also the law relating to pleadings. Similar laws. Whenever injustice is meted out to a large number of people, the court will not hesitate in stepping in. Articles 14 and 21 of the Constitution, as well as the International Convention on Human Rights, provide for reasonable and fair trial. And then they've quoted Maneka Gandhi. 4. The common rule of locus standi is relaxed so as to enable the court to look into the grievances complained of on behalf of the poor, the depraved, the illiterate, and the disabled who cannot vindicate the legal wrong or legal injury caused to them for any violation of any constitutional or legal right. The word used is any constitutional or legal right. I understand that a judgment is not a statute, but the drift of it doesn't have to be a fundamental right alone. A constitutional obligation such as the one enshrined in 371A also would. Then note 5 is important. When the court is prima facie satisfied about variation of any constitutional right of a group of people belonging to the disadvantaged category, it may not allow the state or the government from raising the question as to maintainability of the petition. Note 5 also, with the deepest respect notes, deals with 371A, the petition, and the rights under 371. Although procedural laws apply to PIL cases, but the question as to whether the principles of res judicata or principles analogous thereto would apply depends on the nature of the petition as also facts and circumstances of the case. Not so relevant, just for completeness. 7. this is important. The dispute between two varying groups, warring groups, purely in the realm of private law, would not be allowed to be agitated in a public interest litigation. This really 7 doesn't apply at all. 8, however, in an appropriate case, although the petitioner might have moved the court in his private interest and for redressal of personal grievance, the court in furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. Which is why I was saying that even if it is treated as a representative petition, which is not really the private interest, but even then, and then the court chose on their seeking to withdraw, the court chose to proceed as a suo motu PIL and adjudicate on the issue. So that part would have a bearing over that. And I couple of orders where it has categorically been recorded that there is a great deal of public interest of the Naga people and national interest in terms of the powers of the union, which is at stake. So this is a matter which requires consideration. This court has, in this very matter, this court has said so. May have 9. The court in special situations may appoint a commission or other bodies for the purpose of investigating into the allegations and finding out facts. It may also direct management of a public institution taken over by the committee. To answer my Lord's question, in a given set of special situations, may appoint a question, was the question which fell from my Lord's notes. And then will have, and they give the example of Narmada Bachao Andolan. And then will have 10 at the end of the paragraph, then 11. 10. The court would ordinarily not step out of the known areas of judicial review. High courts, although may pass an order for doing complete justice to the parties, they do not have the power akin to 142 of the Constitution. So, in this petition, we are not going out of the judicial review. Whether an act is valid, is passed, is within the competence of the legislative body passing it. 11. Ordinarily, the High Court should not entertain a writ petition by way of a public interest litigation questioning the constitutionality or validity of a statute or a statutory rule. This is the part where my learned friend said that this is not maintainable. That para 11 says that High Court should not. But it also says ordinarily, and given a circumstance where 1 to 10 are involved, in this case, like 1, 5, 1 is involved, 5 is involved, 2 is involved, 3, which is a large group of people, and there's no private interest, so to say. So that's where it summarizes. And then it goes on to several other judgments also. But those are the in MC Mehta in 142, they expanded it. I just read that, it's quite interesting. In MC Mehta, it was held, the scope of Article 142 was considered in several decisions and recently in Supreme Court Bar Association, by which the decision of this court in Vinay Chandra Mishra was partly overruled. It was held that the plenary powers of this court under 142 are inherent in the court and are complementary to those powers which are specifically conferred on the court by various statutes. This power exists as a separate and independent basis of jurisdiction apart from the statute. The court further observed that though the powers conferred on the court by Article 142 are curative in nature, they cannot be construed as powers which authorize the court to ignore the substantive rights of a litigant. The court further observed that this power cannot be used to supplant substantive law applicable to the case or cause under consideration of the court. Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier, by ignoring express statutory provisions dealing with the subject and thereby achieving something indirectly which cannot be achieved directly. So even on 142, they placed some restriction that it has to be concomitant with existing power to supplement it to enable full justice being done. But it is not a source of independent power which is dehorse the constitution, dehorse the power of judicial review, or dehorse the statutes under which the issue, whichever is concerning the court's attention at that time. Now, please see Balco also for a moment, just one paragraph. In Balco, they clearly said that where, I'll just read that. Public interest litigation, or PIL as it is commonly known, entered the Indian judicial process in 1970. It will not be incorrect to say that it is primarily the judges who have innovated this type of litigation, as there was a dire need for it. At that stage, it was intended to vindicate public interest, where fundamental and other rights of the people who were ignorant or in socially or economically disadvantageous position and were unable to seek legal redress were required to be espoused. PIL was not meant to be adversarial in nature and was to be a cooperative and collaborative effort of the parties and the court so as to secure justice for the poor and the weaker sections of the community who were not in a position to protect their own interests. Public interest litigation was intended to mean nothing more than what the words themselves said, which is litigation in the interest of the public. While PIL initially was invoked mostly in cases connected with the relief to the people and the weaker sections of the society and in areas where there was violation of human rights under 21. But with the passage of time, petitions have been entertained in other spheres. Professor Sathe has summarized the extent of the jurisdiction which has now been exercised in the following words. PIL may therefore be described as satisfying one or more of the following parameters. These are not exclusive or merely descriptive. Where the concerns underlying a petition are not individualist, but are shared widely by a large number of people. Bonded labor, under trial prisoners, prison inmates. Where the affected persons belong to the disadvantaged sections of society. Women, children, bonded labor, unorganized labor. Where judicial lawmaking is necessary to avoid exploitation, inter-country adoption, the education of the children of the prostitutes. POSH is also that is the result of judicial PILs also. Where administrative decisions related to development are harmful to the environment and jeopardize people's right to natural resources such as air or water. They'll come back to this last one, at some point of time, on the regulation part, on why regulation is required in the oil field sector. There is in recent years a feeling, which is not without any foundation, that public interest litigation is now tending to become publicity interest litigation or private interest litigation, as I said, has a tendency to be counterproductive. PIL is not a pill or a panacea for all wrongs. It was essentially meant to protect basic human rights of the weak and the disadvantaged, and was a procedure which was innovated, where a public-spirited person files a petition in effect on behalf of such persons who, on account of poverty, helplessness, or economic or social disabilities, could not approach the court for relief. There have been in recent times increasingly instances of abuse of PIL. Therefore, there is a need to re-emphasize the parameters within which PILs can be resorted to by a petitioner and entertained by the court. This aspect has come up for consideration before this court, and all we need to do is recapitulate and re-emphasize. And when they went on in Balco, would recall Balco was concerning the disinvestment in Bharat Aluminium, and the court came down quite heavily, saying that this is an economic policy the government of India has taken. Really, there's no scope for any, and which also tied up or dovetailed into the concept of judicial review vis-a-vis economic decisions, which was very limited sphere, and in a public interest to seek to enlarge that scope to say that an economic policy or an economic decision is subject of judicial review to the fullest extent possible. On the reasons for which, the causative reasons why the decision is taken, the process, how it is taken, and the decision itself. Now, we all know that courts have said on economic policy only the procedure. If the procedure is followed, the court will keep its hands off. Nothing more needs to be done. So, which is what in Balco they said that you can't really go for the causative reasons or the quality or the nature of the decision that is taken. The process is followed, statute is there, disinvestment is permitted, policy of the government, period. This entire thing was done. Now, coming to this, there are two recent examples where would recall. The most recent one is the farm laws. Would recall the farm laws came, and typically as happens, there was some agitation, matter went to the Supreme Court, petitions were entertained. It's not as if petitions were not entertained. We'll just have these orders for a moment. And not just entertain blows, in fact, the application, a stay was granted on the application of the act. Blows will have, and these are blows will see, it says with WPC 1152 PIL. Hello, with me? Right on the, let me copy this. It's WPC 1118 of 2020.
Take a short break and come back.
No. Okay. My submission on the public interest litigation and the jurisdiction of this court, I was just going to cite that order of the Supreme Court in the farmers' protest matter, if will have that order. Right at the start, where it says, para 2. We have before us three categories of three categories of petitions, all revolving around the validity or otherwise of three laws. That's a Farmer Produce Trade and Commerce Promotion and Facilitation Act, Essential Commodities Amendment Act, Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services, and the protest of farmers against these laws. One category, para 3 is quite interesting. One category of petitions challenge the constitutional validity of the farm laws. So that's one bunch of matters. Included within this category of petitions is a petition under Article 32 challenging the validity of the Constitution Third Amendment, by which entry 33, will recall, entry 33 relates to trade and commerce, was substituted in list 3, concurrent list in the 7th schedule of the Constitution, enabling the central government also to legislate on a subject which was otherwise in the state list. Another category of petitions are those which support the farm laws on the ground that they are constitutionally valid and also beneficial to the farmers. So that's a competing one. The third one is quite interesting. Third category of petitions are those filed by individuals who are residents of the National Capital Territory of Delhi as well as the other neighboring states, claiming that the agitation by the farmers on the periphery of Delhi and the consequential blockages of the roads, highways leading to Delhi infringes their fundamental right, infringes the fundamental right of other citizens to move freely throughout the territory of India and their right to carry trade and business. Now, please see, after that, they record if we'll have para 8. In the other paragraphs, my lords have recorded the situation of the negotiation. Be that as it may be, the negotiations between the farmer bodies and the government have not yielded any result so far. Therefore, we are of the view that the constitution of a committee of experts in the field of agriculture to negotiate between the farmers' bodies and the government of India may create a congenial atmosphere and improve the trust and confidence of the farmers. I'll pause over here for a moment. Malod would recall the court had also set up a mediation committee where three Mr. Panchu and two other, I believe Mrs. Ramachandran, who we lost only last week, and Mr. Hegde. All three had been nominated to mediate a settlement which failed. We are also of the view that a stay of implementation of all the three farm laws for the present may assuage the hurt feelings of the farmers and encourage them to come to the negotiating table with confidence and good faith. That would be a strange reason for granting an injunction, but nonetheless. When we put across the above suggestion, the learned attorney, even while agreeing with the constitution of a committee, opposed vehemently the grant of an interim stay of the implementation of the farm laws, drawing our attention to the law laid down by this court, in such and such cases. The learned attorney contended that the court should not stay the implementation of the laws. He argued that none of the petitioners who has attacked the farm laws have pointed out even a single provision which is detrimental to the farmers, and that the laws enacted by parliament cannot be stayed by this court, especially when there is a presumption in favor of the constitutionality of legislation. Though we appreciate the aforesaid submission of the attorney, this court cannot be said to be completely powerless to grant stay of an executive action under a statutory enactment. Even very recently, this court passed an interim order in such and such case directing the admissions to educational institutions for the academic year 2021 and appointments to public service and posts under the government shall be made without reference to the reservation provided. Note, would recall, even the medical admissions. Look, that is something which is completely, before the need thing being devised by the Honorable Supreme Court. The entire system of counseling and how medical seats are to be allocated, all devised by the Supreme Court. So that's the contours of the powers under 32. Well, then in 11 notes that the farmer bodies have agreed to go to the 12 is important. Mr. V. Chitambarish, known as Senior Counsel of Hearing of Bharatiya Kisan Union, submitted that the union which he represents is not agreed by the farmer. Sridhar Potaraji, hearing of the Consortium of Indian Farmers, submits that his client represents 15 farmer unions across 15 states, and they will be badly affected if a stay of the implementation of the farm laws is ordered. This is for the reason that farmers who represents cultivate fruits and vegetables, and that about 21 million tons of fruits and vegetables will rot if nothing is done at this stage. In so far as the apprehension regarding MRP is concerned, no safeguards have been built. Now, 14 months, having heard different perspectives, we deem it fit to pass the following interim order with the hope and expectation that both parties will take this in the right spirit and attempt to arrive at a fair, equitable, and just solution of the problem. The implementation of the 3 farm laws shall stand still until further performance.
This, what is this abbreviation PILW? What does it mean?
No, there will be public interest litigation with.
Okay. Okay.
W would not stand for it. on similar lines, is the second judgment, with second order actually, which we filed. And so I, by Guru, by you know, I'm just trying to assist this honorable court by pointing out that those are the contours in which a PIL may be entertained, and those active examples of where they are being entertained. If we'll have, this is the Delhi High Court, and we'll have para 3. Present public interest litigation has been filed challenging the constitutional validity of sections 2(1)(g), 11, 13, 14, 15, 16, and 39 of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013, as well as the provisions of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Rule 2013 has been violated of 14, 17, 21, and 23 of the Constitution. When we come through the petitioner submits, states that the definition of manual scavengers under 2(g) of the MS Act is not only manifestly arbitrary, but also against the principles of reasonable classification, as it excludes from its abuse sewer cleaners and septic tank cleaners doing hazardous cleaning, in as much as they also clean, carry, dispose of, and handle human excreta from dangerous places, and further deprives them of the benefit of identification and rehabilitation provided under section 11 to 16 of the MS Act, read with the rules and other beneficial schemes bought by the government from time to time. Further states that the explanation A of 2(1)(g) of the MS Act is discriminatory in nature, as it also encapsulates regular and contractual employment to the exclusion of people cleaning excreta on daily wages, temporary workers, and judgmani workers. He also states that the explanation B of 2(1)(g) of the Act, by excluding person engaged in cleaning of excreta with the help of protective gear from the definition of manual scavenging, has deprived them of the benefit pertaining to rehabilitation scholarships for which they are equally eligible, in as much as the nature of the work remains the same. Issue notice, and then Manoj, petition is now entertained. The constitution. As far as this jurisdiction of public interest litigation is concerned, in my very humble submission was, I don't think this is an impediment. For this court to consider the validity or the writings of the rules and the regulations, the PMV regulations and rules which are under challenge in the petition. Those are my submissions as far as the first thing that I had mentioned in the morning relating to maintainability. I did mention the look, as far as the maintainability issue is concerned, would you like to hear that from both sides and close it?
So you complete your part so that it's easier for us.
Yes.
Because again, then if it is spread in parts, then we can't pronounce the order.
Oh, no, I was just wondering if, as done by the Supreme Court in that West Bengal case, we would like to pronounce a short judgment on maintainability so that that is over and we are on the main matter. Otherwise, I can proceed with the main matter.
You proceed because you see, This is a matter of, last time also I said,
2015.
is a 2015 matter and 2020 is converted to PIL. Now to take up maintainability only.
Look, I
repeat-
close hands. I'm here, look, I can.
It will be taxing not only to us, but also to you. To again come and argue on merit.
Yes. No, but from the way you know this has shaped up.
Because that's why in the previous order, paragraph 5, we made a mention. So that we proceed with the matter.
Yes, that there's no doubt. I was only whether the maintainability issue will deal with, and then it could be a short order also, so that for
But
future
now
it's done.
with this, with this and the broad arguments which have already been made, now the scope of further argument is very, very less on the issue of
670
the-
running.
Hmm?
Was it taken?
Okay, I don't know.
It
No,
will
the
take-
contours which,
It won't take weeks, but it'll take, at least, I think 1 or 2 days it will take.
okay, so we begin with that also.
Look, I'll start today. And look, whatever I can complete in one, and that's what, whenever it's my work.
Just a moment, that's yes, we would prefer that you continue with the
Yes,
submission.
Look, now, look, the second part of my arguments are going to be on 371A. Because even before I read the constitutional provision, look,
Because we'll also have to understand our difficulties.
I fully,
There's again a bench break.
you know,
Today I am, so far as we are concerned, for myself, I have 3 bench today. A 2 division bench and a single bench. My brother has a same thing, second DB and then single. So
sometimes it baffles
to
me.
keep a track of what we were hearing is at times is very difficult.
I'm always.
I think you have with you proposed issues which was handed over earlier. There's a proposed issues. I think if memory serves us right, Mr. Raju was arguing. I think he gave this. Just check it out. Yeah.
We could go through the proposed issue. Some of these will probably covers.
The last few hearings, we lost a track of that. In the last few hearings, we lost track of that.
Yes.
Huh.
No, we go through these.
Huh.
Look, I saw these. Look, I thought that many of these, I don't think these are issues framed by the court. These were handed over.
Yes.
So some of these are overlapping,
Hmm.
in my very humble submission. So, maybe we could just club them and identify the issues, I would be. Yeah, sure. In fact, all these 8 issues relate to the one issue was according to it. I just not walk with my notes through these issues. If we will have a problem. Yes. Whether Article 371A(1), which enables Legislative Assembly of Nagaland to restrict by resolution the applicability of any list 1 or list 3 central law passed by the Parliament on any of the 4 subjects mentioned in 371A(1), simultaneously confers a legislative competence to the Legislative Assembly of Nagaland to pass laws on the subject not covered in list 2 or list 3. So, and if you will see 2, it says to elaborate the above, whether 371A(1) can be pressed into service by the Legislative Assembly of Nagaland for converting list 1 into a concurrent list, by claiming that despite being a state, it has a power to legislate in the legislative field exclusively covered by 53. But others also, aside from the fact that the consequential whether the rules and regulations are widely or not, essentially this in my view covers one issue, which is not the true nature of 371. Is it a disabling clause where laws to protect, as I mentioned the last time also, the social, cultural, natural identificatory characteristics of Naga society and customary law? Or is it an enabling provision which independently grants competence to the Naga Assembly to legislate on fields which are not mentioned in list 2 or list 3? And I make good this submission when if are to consider the 3 lists, will see that there is no, in my very humble submission, there is no friction, there is no dispute. I'm so sorry. Oh, I thought I was going to say something. I'm so sorry. So there is, in my very humble submission, there is, if every entry is placed where it is supposed to be, and not by my submission, as the Honorable Supreme Court has and various high courts have placed there is no friction, there is no dispute at all. It's only when we give an overarching meaning to 371A, where we say that the word notwithstanding, where it opens up with, means that dehosts the Constitution, dehosts the basic structure of the Constitution. This is a standalone provision which is over and above the Constitution. Then there is a problem. But if we consider 371A a part of the Constitution, subject to the rigors of the Constitution and the basic features, then there is no dispute at all, no friction also. So the first part is going to be whether this competence flows with a disabling resolution as was envisaged under 371A.
कुछ लगे नहीं ना ना ठीक है थैंक यू
Mr. Kohli, that by that order, the PL was converted to suo motu. If you look at that order, 4/2/2019. Last page. We therefore direct the registry to register the said PL as a suo motu PL.
Yes.
Uh,
So direct the registry.
There are up to small Roman 1 up to small Roman 6. Small Roman 1 is the Nagaland Petroleum and Natural Gas Regulations 2012. Roman 2 is the Nagaland Petroleum and Natural Gas Rules 2012, framed under Regulation 24 of the said 2012 regulation. Now here, there is an act, the Nagaland Ownership and Transfer of Land and its Resources Act 1990, passed by the Nagaland Legislative Assembly. That is not within the scope and ambit of the PIL.
It's not.
The rules and the regulations are only within the scope of the PIL.
Yeah.
So, even if, suppose, even if the regulation and rules goes, the act has to go. Unless the act does not go.
Yes.
And this is not within the scope and ambit of the PIL, the act, which was passed as far back as in the year 1990.
99.
We are after 34 years.
Yes. Yes. But no, there's one little, I fully follow what falls from my note. No, then there's one little off note. Yes. At page 66, my note that 1A4 of 371A of the Constitution, no act of Parliament in respect of the ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. No such resolution has been passed by the Legislative Assembly of Nagaland. In the absence of such resolution, it has become necessary for the Legislative Assembly of Nagaland to regulate by law the ownership and transfer of land and its resources in the state of Nagaland. Yes, land and its resources means advantages derived from the surface of the land and all that is below it and which is valuable or is a source of money or income and includes minerals, mineral oil, petroleum and petroleum products, including liquefied petroleum gas, and every other product of mines, including forest and forest products. No person shall undertake any prospecting or mining operation in any area in the state except under and in accordance with the terms and conditions of a prospecting license or as the case may be a mining license granted under this act and the rules made thereunder. No prospecting license or mining license shall be granted to any person unless he has a certificate of approval in the prescribed form by the state government satisfies such other conditions as may be prescribed by the rules. No explanation for this, for the purpose of this subsection, a person shall be deemed to hold a certificate of approval, notwithstanding that at the relevant time his certificate has expired. No prospecting license or mining license shall be granted to any person who is not an Indian national. Yes, but look, in fact, it's a slight little twist there, Manoj. So, Manoj, what happens is, and may I just broadly state my case before I get into the entries and everything. So, Manoj, what happens is that in 371(8), there is a non-obstante clause.
Just a moment before we begin. The underlying query is that would the exercise of hearing be academic in light of the absence of challenge to the act? That is the reason we are asking this first.
Yes, Manoj, to that extent, Manoj, in my respectful submission, Manoj, in the manner the constitutional entries are framed, mines and minerals is different from mineral oil, because mines and mineral comes under the state list, while oil comes in list 1. So, Manoj, the fundamental premise of the argument is, Manoj, that the moment there is a disabling resolution by the legislative assembly, Manoj, the question which arises is, where does that competence for that field go? Manoj, undisputedly, since it's a central act, it has to be with Parliament. So, Manoj, it can be either list 1 or list 3. Now, Manoj, as far as list 3 is concerned, the moment a disabling resolution is passed, Manoj, in my very humble submission, Manoj, the disabling resolution doesn't really address 245. It addresses 254. Because, Manoj, if a state government is to come out with an act which is not in a field already occupied by a parliamentary act, then, Manoj, you need the presidential assent for it to be applicable. What 371(a) does is, it simply says, no, I don't need the presidential assent. Your act will not apply. And now, Manoj, there's a vacuum. Or is it? Because, Manoj, the vacuum is covered by the state's competence in list 3. And similarly, Manoj, where in list 2, mines and minerals, but in list 1, there is, Manoj, an omnibus entry 54, which says that once the public interest, expediency declaration is there, then, Manoj, 23 mines and mineral transposes to list 1. And the parliament is, Manoj, in a position to make a law. Right.
Please explain this again.
Look, so 371,
Let's just
I'm so sorry.
The submission which you made involves 3 facets. Number 1, that what is land and resources? The second aspect is the oil and natural gas. And the third is mine and minerals. You're trying to bracket them in different lists, and then you are trying to explain. Please explain further, let the elementaries be clear.
No, so I'll just explain. So
Huh?
my submission is this one. I'm so
In very common parlance.
sorry. As common
First,
as,
that in common parlance, then we can go deep into it.
yes, but as common as legal provisions will allow me.
As common as R.K. Lakshman.
No, here's what my submission is. Because my submission is that the basic federal structure of the constitution is that the legislative power is distributed across the three lists. That's where the competence flows from. I make good this submission that competence under this constitution flows only in part 11. The various possibilities, whether it's national interest, whether it's emergency, whether it's states getting together requesting the center, competence flows from chapter 11, chapter 1, part 11. I'll take my notes through that in detail. Now, look, once we accept that, now 371A notes deals with 4 subject matters. So my notes will have to first consider notes a disabling provision where they say that any act of parliament we can say will not apply to it. So the presumption over there is the act of parliament is within the competence of the parliament. Now, when that act is passed, either it is in list 1 or list 3 has to be. Now, once that act is passed, the Naga Assembly says this act will not apply to us. No, the natural question that follows is who has the competence to legislate on that field? Now, I'm saying that as far as list 3 is concerned, it's a simple answer. Where the Parliamentary Act doesn't apply, under list 3, competence lies with the Naga Assembly, the State Assembly, and they can enact. But over here, why did I mention 254? Because where an act of parliament is there, occupies a field. And the state makes an act on the same field. Then the principles of repugnancy would apply unless there is a presidential assent to the State Act. Now, 371A, why did I say 371A relates to 254 is because 371A doesn't say that I will then recommend to the president or I will seek the presidential disaffection for the act of parliament. No, it simply says your act will not apply. And I don't have to go to the president to acquire my competence in list 2 or 3. That is inheres in me under the constitution. So, the disabling provision under 371A directly relates to 254, where the presidential assent is no longer required because there is no occupied field. The Central Act doesn't apply. The tricky part is notes that the tricky part is that as I'm so grateful notes for that you notes 4 371A 4 deals with on the one side it deals with ownership and transfer. That's one subset of land and its resources. Now, what my lords will have to consider is land and its resources. Now, land is distributed in various facets over the 3 lists. Note will find agricultural land in list 2. Note will find transfer of property act in list 3. the competence to enact on transfer ownership of property and its registration in list 3. As far as the resources are concerned, my lords will find them in list 2, list 3, and then in list 1, 2. In list 1, my lords will find in entry 53, where there is an entry which simply says mineral oil and petroleum products are all to be regulated by the center, not ownership or transfer, only regulated.
First, we want to know land and its resources. Resources of the, it clearly means resources of the land.
Yeah.
So how do you break it?
Yes.
Land and its resources.
Yes.
Meaning that thereby resources of the land.
Yes.
So what is resources of the land?
Over there, it's a very, I'm so
That is
grateful.
what we are asking.
Yes, I'm so grateful, because there
That
are judges
should be what is above the land
above the land, on the land,
and below,
below the land.
That is what I am asking.
Yes,
What
I'm,
is the authority on it?
yes,
Or any interpretation on it?
there are,
Because I think 9 judges might have gone into it.
has gone into it,
First, we would like to understand it.
yes,
It will be very easier for us.
may take it, my submission is going to be below, on, above, goes with the land, resources. That's what the line of judgments is. I'll make that good. I'll take my lords, but as my lord said in the simplest layman terms, the answer is all covered. That the Supreme Court has
So
said.
petroleum is beneath.
Is there. But I'm not for a moment suggesting that the competence to legislate below, on, or above goes with the land. Because the Constitution doesn't say that. Which is why I said the various facets of land.
Land and its
Resources.
That term are to be understood first.
Yes,
Then
clearly, Manoj.
Thereafter, whatever power.
Yes.
legislate,
Wherever it is resting.
That we
Yes,
look
that we look into.
But
But
now it has boiled down to a particular definition because there were many litigations on it.
Manoj,
What is the final?
the crux of it, Manoj, if I may answer, Manoj, in 2 simple lines. Manoj, what the Supreme Court has through Manoj's line, a thread of judgments held is, and which is where Manoj, my learning in this case was, I was also under this mistaken impression, Manoj. What they've said is land and resources below, on, above will go with the land. It's land and resources. That's one part. The second more interesting part, Manoj, what they've said is, it doesn't belong to the government. The resources belong to the person who has the land. The proprietary rights on the land, to him belong, or to her belong the rights on the resources. So, in the MMDR Act and in the Oil Fields Act, everywhere, there is this concept, the duality, where they have regulations for land owned by government, how it is to be regulated and prospected for mining, and land owned by private people on how that is to be regulated. So, my submission is going to be that as far as these acts are concerned, none of them touches ownership and transfer. None of them touches ownership and transfer. They all talk about regulating the development, exploitation of mines, minerals, and resources. So, as far as clause 4 in 371A is concerned, when I come to the ownership and transfer point, my endeavor would be to show that regulation doesn't impinge upon ownership and transfer in faith and substance. So I'm not touching. So, in the long shot is that the resolution passed by the Naga Assembly relating to the Oil Fields Act is misplaced.
That is what. Suppose me as an individual
Yes.
have 1,000 acres of land. And I find that beneath the land there is petroleum.
That's doubly lucky. 1,000 acres and then
Hypothetically. Hypothetically like. Then who can explore that petroleum. That is the issue. As simple as that.
As simple as that.
Whether
Crux of it.
myself or the government will come in. And out of the two government, whether central or
State.
state. That is the issue.
Yes, that is the issue. But look,
Because Nagaland is peculiar,
peculiar.
land
Yes,
system,
land and resources.
that is peculiar to Nagaland. So
And
that is why.
And the point is that double lucky is that's not the point. The point is that all good people and wise people have said, think big.
Yes. So notes over there, no, I'm grateful for what falls from my notes, but there's just one practical aspect which notes was misunderstood in the last time notes when I had mentioned it. So notes when we go for the exploitation of these minerals, there is one which is probably like to give a very simple example, coal. Or any mineral which can be excavated open. That's the simplest. I simply go there, I pick it out, I separate the earth, all possible by the owner. The owner can hire labor and we can do this. But no, when you go to subterranean minerals, when you go to gas, when you go to petroleum products, which could be between 1,500 meters below the surface to 5,000 meters below the surface. Now, I'm not going offshore to the continental shelf. No, we are not concerned with that. But even onshore, the distance could be running from meters to thousands of meters. There is a fair amount of capital expenditure which has to be incurred to exploit that mineral. Which is why the regulations all talk about a commercially viable discovery. And finding oil is one thing. Whether it is commercially viable is a separate issue. And commercially viable means that the money that you will end up spending to extract, refine, and make it into a marketable product, the amount of capital you spend must justify, the return must justify the spend of that capital. Or the social benefit from a government angle, the social benefit of, let us say, having energy security requires that I go ahead and dig it even if it's not commercially viable. But I'll excavate it because I want energy security in the geopolitical space. 84% of our energy is imported.
I think that is not the issue here.
That's not the issue. But I'm only saying when we go for a commercial development, there are economic factors which will decide who will exploit it, how it will be exploited, and of course, who will be the beneficiary of that exploitation. So, will it be the landowner or will it be a shared resource?
Taking the hypothetical example further, that 1,000-acre large storage of petroleum beneath it. I am sitting over it.
Yes.
But government of India wants to explore.
Yes.
What is the mode?
The mode.
You have to either acquire my land.
That could
suppose it is in Nagaland.
I can't acquire.
You can't acquire. You can't explore also then. I am sitting over the land.
I can. Which would effectively mean
how?
That then
what is a mode?
Yes. So effect.
Yes.
To answer my notes directly, even if the land owner, in this case, wishes to exploit the resource, can't do it. Unless he complies or she complies with the regulatory environment. Because it can't be that there are many stakeholders. Whenever we go and exploit this, there is labor, safety, health, hazard will all have to be taken care of. It's an open pit. It can't be that you go around felling trees indiscriminately. So there will be an environment angle also before and after the exploitation is complete to restore the land to its original position. So, Manoj, what the central government as a stakeholder will do is regulate that development, not ownership transfer or anything, only regulate the development so that all the other facets, other stakeholders, their interest is protected. The owner remains the owner. Now, Manoj, if the owner has some economic difficulty, as Manoj in a large kind of a thing, Manoj, because ultimately, even if I get the oil, I need to transport it. So, Manoj, I need to tie myself down to various contracts with various players so that I can hit the market. Now, Manoj, when that owner comes in contact with third parties, whether the government, it could be ONGC, it could also be Reliance, which is a private party. Now, Manoj, when they come in touch with the third party, that contract may define what their contractual commercial arrangement is. The government through these acts is only regulating how you go about prospecting, how you go about mining. If Manoj will allow me, Manoj, since this is going to be a little complicated, the 2 or 3 page note just broadly laying out the competing entries and everything, if Manoj will allow me,
Yes.
it will help a lot. I like that.
So because of the distribution of bench we are having, the determinations we are having, at best in the second half we can extend to 2:30. You want to do it or you want to do it another day?
No, I will not be able to finish in half an hour. So I'll take another date and I'll try compressing load so that at least I'm able to cover. So there are two facets to my arguments. One is the true contours or nature of the disabling resolution and whether it is well placed or misplaced. And the other is relating to the competence, whether it transfers or not, and whether the oil field act will apply or not. Those are the two facets. It will take a little while. There are some entries which will have to consider.
We propose a date in the next week.
Manoj.
What is when that 9 judges meant mines or minerals, something, some
Yes.
judgment? What is the
No,
judgment?
that came only 2 weeks back. I'll get that also. That actually deals with this quite in detail. I think that would be very helpful.
Lordships, with regard to the 9-judge assessment 2024 SCC online, Supreme Court 1796. That the order of which was passed on 25th July.
What is the name of the parties?
Mineral Area Development
Development Authority.
9-judge assessment, Lordship, which was delivered on 25th July.
Drop it on my notes iPad. I have a copy. I'll just drop it on my notes iPad.
Mineral area development.
Mineral?
Area.
Area
Development Authority.
and others versus MS Steel Authority of India and another.
I'll give a copy. My learned friend will hand over a copy to this honorable.
It's okay. We will get it. Don't worry.
Yes.
It was delivered on which date?
This will take
25th July
25th.
2024.
Delivered while arguing the case.
Yes, yes.
The day when Lordships has heard the matter.
The civil appeal number 4056.
Just someone from the name, I think we can. Steel Authority of India.
Mineral development.
How we have it?
Yes.
Lord, may not keep it. Week after that.
Huh?
Week after that, 22nd. Unfortunately, one matter which is going on, is still on 15th.
Okay, because I think Mr. Kohli will be continuing. Okay. Means, because this month we are here, so that's why the urgency is that at least we can continue the hearing, otherwise.
Or Manoj would consider
14.
I don't know, 16th. No, 16th, I believe, is working for the court.
Yes.
16th is a
16th,
Friday.
it will be sandwiched between two holidays, we don't know.
No, I'll be there.
No, means.
Yes,
the
I
work
know it's a
pressure will
long
be more.
weekend. Manoj, 19th is a Rakhi also.
What happens is that in the sandwiched open day, we have a lot of miscellaneous
Oh,
matters coming up.
Okay.
So that's why.
Manoj,
14th will
consider
be okay.
19th in that case.
19th is Raksha.
We are very close to 22nd,
Ah.
we hear it.
Okay, then 22nd.
22nd, Manoj. 22nd, I'll be in some difficulty. Manoj.
20 then, 20. Everything.
No, 19th I can be here. No, Monday morning I can be here. Monday is off in Delhi High Court and Supreme Court also. Manoj.
Okay.
19th.
19 is a holiday.
No, 19th is not a holiday.
19th is a working day here.
It's a working day.
I think the principal seat.
Let's have it on 20th. 19th and 20th.
Lord Chiefs, on 20th, the High Court Bar Association General Meeting has been called,
Oh,
and I'm the president, Lord Chief.
then 20, let it be 20. Let him.
Lord Chief, 20, our meeting is on 20.
Oh, sorry. Because he will address, you can be. Because it will be his submission right now. I think he says that he will continue on that day.
19, I have no difficulty, Lord Chief.
Okay.
19th I can do. Manoj.
Okay.
19th.
19 then. No, because we'll spill over otherwise also. Huh?
No, same half day only, or Manoj would go for the half day.
Roster
I don't know.
is not within our,
Yes, I know.
within our domain.
No, I'll try to complete as much as I can, and on 20th.
19th.
On 19th. I'm so sorry. 19th.
19 we may spill over to 20. Huh?
No, 19th we'll do. Manoj.
Okay.
19th is off, and I'll try to Manoj,
Okay.
do it as.
Let's see. The names are there in the last order. Huh? So that the submissions of
29th.
Mr. Vivek Kohli, the senior counsel, remains inconclusive. There are a list for further hearing on 19/8/24. Yeah, give your name because your name, I think, was not recorded last. Huh? Okay.
I'll keep my video down.
MS R. Chaudhary, Your Lordship. She has some personal difficulties only for today, Your Lordship. Next. Oblige, Your Lordship. Lordship.
Division bench item 1 for hearing.
Your Lordship, due to some personal difficulties, Angel Council is not coming today. So kindly adjourn the matter today.
Item 2.
Make legal lawsuits. Impugn judgment is at page 57. Here in the case petitioner exhibited 1966 brutal list, exhibit A, her father's name.
You have to speak loudly. We are not hearing your voice.
Lordships in the impugn order is at page 57.
Yes.
In this case, Lordship, I exhibit A, 1966 brutal list of my father and mother. And then
Is your Kabindama there? No.
no Kabinnama is there. Only linkage certificate issued by the secretary who was examined, Lordships, exhibit C. And
Any voters list you have along with your father?
no brutal list, Lordship. After marriage, my brutal list appeared with my husband, Lordship, my name. That was Annexer 5, 2005 brutal list.
But
Petition type along with the husband.
there would be a disconnect.
There is no connection with my father, certainly, but certificate is there. That certificate issued by the secretary, Lordship, that is page 27, was examined. And one neighbor, Lordships,
No, you see,
72 years of village, who was
this may
also,
be a certificate about your marriage and all, but this can't be a certificate to prove your parentage.
but two persons, Lordships, one villager's Lordship, 72 years old man, he appeared, specifically stated, the secretary also stated on the basis of documents produced, he issued a certificate, and that's exhibit adduced DW2 Lordship, a 72 years old man, Lordship. He knows very well of the family and really stated that the Obirunasa is the daughter of so and so persons. And it was also not also controverted, Lordship. Their evidence also uncontroverted. Details specifically stated in my written statement. One discrepancies appear only in regard to existence of brother, sister, of my father. What questions put to her, I think she may not understand at that point of time. But in the evidence stated, no brother, sister, it is her father, the only son of her grandfather. And the other which is also stated. Only on that count, Lordship, tribunal disbelief. written statement specifically have stated lordships, and all are uncontroverted lordships, and no question put forward that they are not my parents also. Apart from that, that enquiry, only my name appeared. On that basis, cannot be lordships declared to be foreigner. Enquiry has some basis.
But along with your father, names of names of your mother, the siblings, are they there?
Lordship, their name stated lordships. In the written statements, I've
No,
stated.
not a written statement. Any document to show that where the names of the family members are there together. Any
That-
voters list where their names are there together.
Certified copy only obtained only in respect of her father and mother lordships. Grandfather's names.
Where is your own voter list?
That is at page 25 lordships. D was inserted. Vernacular page 26, serial number 902. And husband's name is Syed Ali. 923. 90. 90 on page 26, vernacular. Married people.
Between your statement in the WS
Lordship.
and the evidence, there is some contradiction regarding your presence of your uncles.
Presence of uncles, lordship, the
In your
evidence and
WS, you
lordship.
said your father was the only child.
Yes, lordship.
In the evidence, you said he had two brothers and sisters.
That is contradiction. That's why, lordship, I am making submission. I think at that point she was not understand the what questions put to her. Her father's sisters or her sisters, only on that point, lordships. Other documents also nobody
No,
has
but
challenged. Also.
those ought to have been in place before the tribunal.
But since
You see
I am a
the
married, lordship,
You see the difficulty is that you are picking up only one entry or two entries and then proving it. The entire voters list is not there. So
lordship,
we don't know who are the family members who are there. So why?
whether that voter list has been questioned by the other side and that
It's a
is
question
not
of-
my family members.
No, it's a question of satisfaction of the court.
Satisfaction of the court, yes, certainly, but on the basis of that lordship, I specifically stated only I admitting lordship the contradiction is there. Only the other sister, but
No,
other documents are
initial
documents are-
burden is on you.
other documents, lordships. Tribunal also not disbelieve that it is not the family of the petitioners. And opposite side also state also did not question her evidence also and the documents also it has also not been challenged. And apart from that, on the basis of a report, lordship, enquiry report, only name are entered. D
No, it's-
inserted
no, you
because
see,
of But
The contradiction is major because of the fact that in your support, one Sirajul Haq came to depose as he was DW
DW2
DW2.
lordship,
He also says you are saying that he is 72 years old.
lordships.
So he, with all his wisdom, says that your grandfather was the only child. Your father was the only child of your grandfather.
He also said.
So, but then how siblings are there?
But in the cross part lordships, she stated siblings are there. That's my
So the-
submission is that on what basis, what questions put to her and what she understand at that point of time, she answered them. But specifically stated she has even in the additional evidence also, she adduced.
She was represented by a lawyer. She was represented by an advocate.
At the time of cross lordship, questions put to her, not to advocate lordship.
Maybe, but that difficulty will be there in, even now, assuming we remand it back. How will she understand what questions are put to her?
Now that has to, even if lordship, yes, lordship is correct. Suppose in the evidence I stated my father has no siblings. In the cross I stated my father has two brothers, sisters. But since contradiction, the tribunal has to make a verification whether that earlier statement or subsequent, as per Muslim model case, they have verified.
No.
No, lordship,
Verification, that-
Muslim model's case was
you-
specifically stated.
No, it is not on the burden. It is not the burden of
No,
the burden
lordship,
is not on the tribunal.
since it is a question of lordship citizenship, and apart from that
No.
very inquiry, what inquiry they have done, lordship?
No, they are not required to make inquiries. Tribunal is not required to make inquiries.
Authority, lordship. That authority inquiry report forwarded
You
on
have to-
my name, my
First,
name.
you tell us what evidence you have led to establish the link.
That
You show us one proper evidence that you have led to show the link.
that
You see,
You
it
can't
is,
say that you have not
exhibit
understood.
C, lordships.
you
That is
see,
also
there's-
not
you see, there is one thing.
undisputed. Exhibit C.
In
lordship.
your written statement, in your evidence, you don't say that you are not availing the benefit of the subsidized food grains. So therefore, family cards are not produced. So therefore, there's everywhere you are withholding documents.
Lordship, one opportunity may be provided to her, lordships, for
You show us the ground on which,
lordships,
where,
or
on the
every
basis of
documents,
which.
lordships I have, but only on that contradiction, lordships. Can lordships,
No, now let us say we give you that opportunity, you go back. Show us on what basis you are going to establish that connection.
that verify whether that contradiction is correct or not.
You verify and tell us.
Lordship, since in the cross it was appeared that I
You
stated
verify and tell us that the
Lordship.
statement made in the cross is the correct one.
from the authority also may verify, lordship.
You verify it.
As per Muslim models, case lordship is aware of that. Verification is required.
No,
So,
verification
truth
is
required to take away truth.
where is the
For
question of
example,
Please read
verification?
that.
for lordship,
Please read that part of Muslim Mandal.
lordships.
It does not say that during the course of the trial, then also the verification must be done. Verification is the pre-reference stage.
Yes.
It's not a post-reference stage. That will be somewhere after paragraph 90. In what matter the investigation? Question
Paragraph-
number D.
Lordships,
Question number D. In Muslim Mandal.
in Muslim, yes, Lordship, paragraph, may I refer the paragraph number 94, Lordship, the Muslim order, may I read, Lordship? Paragraph 94.
Yes.
The apex court in Darkar Prasad Agarwal Supra has opined that right to get a fair trial is a basic fundamental human right, and denial of fair trial
No, you see,
violates.
please come to the question first. Then read the para 94. Come to
The-
question D. What is the question?
Question.
Same. Two paragraphs ahead.
On same paragraph.
Two paragraphs before that. Question number D. No, one or two paragraphs before we're reading. You are reading 94. Up
Yes.
to one or two paragraphs before that.
90 strictly. 94. Okay. 92. Yes, 92 paragraph.
Whatever.
In
Yes.
what manner the investigation is to be carried out by the instrumentality of the state before making reference to a
Before
tribunal.
making a reference. It doesn't say after making a reference.
But,
So no point reading any other paragraph.
but reference lordships, that enquiry is only totally blank, lordship. My name only entered. Verify the
Please tell
record.
me, this
But
is the
has
question.
to-
We are taking up this bench for 2 weeks. There's only one question I am asking. If you don't make a statement before the LVO, what will the LVO do? Can he beat you up? Can use third degree method? Can he arrest you? Can he compel you to give an answer?
Cannot.
Then
That cannot. In
Then-
this respect, lordship, I may also
you
rely
see,
upon the
it's
response
okay on that.
regarding
at-
on enquiry
At that
authority.
stage, the inquiry was not made.
referral
Okay,
authority.
accepted. On that day, inquiry was not made. But in your written statement, how you have shown the link? There is only one question.
Written statement, lordship, that certificate is there, lordship. That is not questioned. Secretary has issued the certificate.
That certificate is
And,
not
and the
a,
family members, they are
Show us
not
any
my
authority.
family members. though-
show us any authority where it has been said that a Gaon Panchayat certificate is a proof of legacy.
The legacy, that means at that point of time, for preparation of NRC lordship 2015, it was then, and the case lordships, that for that legacy lordships, authority was directed, that also is required to place before the authority for NRC purpose. And that certificate I have also placed before the court, tribunal lordships, and it was also not been questioned. And it was not denied that authority he has not issued. And the other side also not questioned that it is fake, or
So
they are
you have
not my
done-
family member.
You have done more cases in foreigners traveling than we have heard.
Lordships,
Correct.
only
Now you tell us,
married persons.
what is the law laid down? NRC is not applicable for the purpose
Yes,
of this.
lordships, but
So there's
law
additional
laid down is
pronouncement.
that lordships. If since they have suspected me, I am foreigner, but some enquiry has to be done, lordships. What enquiry they have done? No enquiry at all. Only a piece of paper, lordship. There is enquiry. I am foreigner. My name entered the Bhutal 2005 with my husband. D was inserted. On that basis, that reference been. Can it be said is sufficient, lordship, for declaration of persons? In this regard, recently the Honorable Affection's judgment passed, lordships. in 2000, in this month lawsuit. On 11th July 2024.
Yes.
DW2, 73 years old. It will be that. Hmm.
English. Certificate was issued under duress. That is what he said in the cross.
Cross, I have seen lordships. But at that point of during the documents, even stated that on the basis of documents lordships I produced.
Everything is washed away.
At that point, there was a direction also so to issue certificate to the married persons.
So, Bobby, you are not giving us anything, any material to change the view, which was taken by the tribunal. In the writ petition, there is even no statement that the answers were given without understanding the question. And the only document is your that Gram Panchayat certificate. If that goes, nothing survives in the writ petition.
But when the authority referred the case, there has to be some enquiry lordships. There is no enquiry at all. Like on the basis of a blanket report lordships. Some documents
No.
has to be shown that I am the foreigner.
Mr. Barbia, you still have a scope in this writ petition to improve it. Okay, the inquiry was not there. Let us assume it to be correct for the time being. Then also in this writ petition, you have a scope to improve it. There's no material, no link at all.
Some time may be given lordships.
No time you already have since 2017. We are now in 24. 7 years have gone by. You had a lot of time. This is the only question you knew. When you were filing the writ petition, you knew that is the only question which will be asked.
Lordships. Since question is the regarding citizenship, lordships, but and
No, I get it.
authority also knows lordship that personal concern is the so and so.
You see, no. You see, there was a learned lawyer representing you in the tribunal.
Lordships.
In the cross-examination, DW3 made a statement adverse to your interest. You did not re-examine him again. And he says that the reason for giving it. He also admits that there was nothing, and so therefore on the basis of your application, he made that entries. So it is your own statement. So therefore it falls. I'm sorry, perhaps not in this case.
Some time
Can't
may
do
be
anything.
allowed lordship, right?
No, if you want to take time, you take time at the moment, but after spending some time in the matter, then you
And-
can't adjourn it like that.
One opportunity may be given since the authority also failed to proper inquiry and proper materials for whether I am the foreigner or not. That is also not available in the record.
But this,
That ground, on that
if you
ground,
have to take
lordship,
time, you take time at the
Inquiry-
outset, not after we.
one
hear the
inquiry may
matter.
be given to the authority lordships, whether actually she is not a daughter of son, actually she is a foreigner or not. That is also required lordships.
That is why the opinion was rendered.
Rendered lordships, but I am aggrieved, I challenging that opinion lordships.
What is the recent judgment you are relying on?
Recent judgment lordship, Honorable FS Court lordships, Rohim Ali Elias Abdul Rahim versus State of Assam, others. Decided on 11th July 2024.
Giving a copy. Which paragraph?
Paragraph, various paragraph lordship. First, I am reading lordship, paragraph 20 lordships.
Paragraph?
Paragraph 20, page 15. Bottom lordships, you'll find. Lordship got it.
It is in page number?
Page number 15 lordships.
Yes.
Paragraph 20. Undisputedly, the appellant is not a foreigner recognized as a national by law of more than one foreign country. Thus, the appellant case would not fall under Section 8 of the Act. That being positioned as regards Section 8 of the Act, we venture forward. Next page, paragraph 23. Page 18, top lordships. Thus, married lordship. Thus, the courts for completeness of adjudication has to trace its steps back to the proceeding right to the stage of inception, that is the very initiation of proceedings before the tribunal under the Act. Then a reference to Section 6 else referred lordship Act is warranted. Then paragraph 28. Paragraph 20 is page 31. Page 31, let's say page paragraph 28. Married.
Yes.
The case against the appellant was initiated in the year 2004, alleging that the appellant illegally migrated to India after 25/3/1971 from village so-and-so, police station so-and-so, district Mymensingh, Bangladesh, and was living in a village Kashipur, police station, district Nalbari in the state of Assam in SP reference number so-and-so. It appears that the state examined a sub-inspector of police SIS Bipin Dutto, who was the investigating officer in the case and in his evidence has stated that on 12/6/2004, he was posted at Nalbari police station when the SPB Nalbari directed him to inquire into the nationality of the appellant, pursuant to which on 17/5/2004, he opened a case diary and went to the house of the appellant, informed him about the inquiry and filled up form number 1. This reference was made by the Superintendent of Police under Section 8(1) of the Illegal Migrants Determination of Tribunals Act 1982, I may think it 85, referred as in the IMDT Act, suspecting the appellant to be an illegal migrant on the ground that, on being asked, he could not produce any documentary evidence in support of his hard and entry into India prior to 1/1/1966. Thus, IMDT case number so-and-so was registered before the then IMD Tribunal, Nalbari. The same case was re-registered under the 1964 order as FT case number so-and-so upon the IMDT Act being declared unconstitutionally by this court in Sabandha 1, Supra 12/725. Consequently, the notice issued under Section 8(1) IMD Act became nullity and therefore FT Nalbari case number so-and-so was started and a reference was made to the tribunal. The tribunal answered the reference by order dated as under. Then these are skipping lawsuits. That paragraph 31, page 35. Some repetition in narration is inseparable as obvious from the above. The initiation of the case against the appellant was based on the report submitted by the sub-inspector so-and-so, which in turn was based on the fact that in his deposition he had stated that upon being directed by SP B. Nalbari, he had undertaken an inquiry against the appellant and asked him to show the documents regarding his Indian nationality, whereupon the appellant had asked for time and was given 7 days time, but did not show any documents, and thus so-and-so filled up form number 2 and submitted his report along with the case diary before the authorities. It is further stated that from such inquiry, it is revealed that the appellant had illegally migrated to Assam from Bangladesh after 25/3/1971, and based on the same, the opinion given was that the appellant was a foreigner. Section 9 of the Act stipulates if in a case not falling under Section 8 of the Act, any question arises as to whether a person is or is not a foreigner or is not a foreigner of a particular class, the person concerned must prove that he is not a foreigner or not foreigner of that particular class. This provision prevails notwithstanding anything in the Indian Evidence Act 1872. However, the question is that does Section 9 of the Act empower the executive to pick a person at random, knock at his or her their door, tell him or her them, we suspect you of being a foreigner, and then rest easy basis Section 9. Let us contextualize this to the fact at hand. The originating point of inquiry is the SPB Nalbari's direction to Sub-Inspector Dotto on 12/5/2004. The pleadings and the record are silent as to what was the basis of the SPB Nalbari's direction, what materials or information had come to his knowledge or possession that warranted his direction. Obviously, the state cannot proceed in such manner, neither can we as a court countenance such approach. First, it is for the authorities concerned to have in their knowledge or possession some material basis or information to suspect that a person is a foreigner and not an Indian. In the present case, though it is mentioned that from inquiry it was revealed that the appellant had migrated illegally to the state of Assam from Bangladesh after 25/3/1971, but nothing has come on record to indicate even an iota of evidence against him, except for the bold allegations that he had illegally migrated to India post 25/3/1971. It is also not known as to who, if any person, had alleged that the appellant had migrated to India after 25/3/1971 from village so-and-so, police station so-and-so, district Mymensingh in Bangladesh. It needs no reiteration that a person charged or accused would generally not be able to prove to the negative if he/she is not aware of the evidence material against him/her which leads to the person being labeled suspect. Ipso facto, just an accusation cannot lead to shifting of the burden to the accused unless he/she is confronted with the allegation as also the material backing such allegation. Of course, at such stage, the evidentiary value of the material would not be required to be gone into, as the same would be done by the tribunal in the reference. However, mere allegation, that too being as vague as to mechanically reproduce simply the words which may mirror the text of provisions in the Act, cannot be permitted under law. Even for the person to discharge the burden statutorily imposed on him by virtue of Section 9 of the Act, the person has to be intimated of the information and material available against him, such that he/she can contest and defend the proceedings against him. In the present case, it is specifically alleged that the appellant had come to Assam from village so-and-so, district Moimosing in Bangladesh, while making a reference to the tribunal. Hence, it was incumbent on the authority making the reference to provide details as to how it had received such information, as also its bona fide belief of such factum being true. In other words, the authority had been, as claimed, able to trace the appellant's place of origin. Surely then, the authority had some material to back its assertion. The record does not show such material was given either to the appellant or the tribunal by the authority. In the absence of the basic primary material, it cannot be left to the untrammeled or arbitrary discretion of the authorities to initiate proceedings which have life-altering and very serious consequences for the person. Basis, hearsay, or bold and vague allegations. In neither round of the proceedings before the tribunal, whether it be the initial expert one or even after the matter was referred by this court to the tribunal to hear the appellant and pass an order, has it been revealed as to how and from where such specific allegation down to the alleged village of origin of the appellant in Bangladesh was brought to or came to the knowledge of the authorities, nor do we locate any supporting material. In the present case, clearly the authorities concerned have gravely faulted by construing the words, a copy of the main grounds on which he is alleged to be a foreigner, in para 3.1 of the 1964 order to mean the allegations leveled against the persons. This error at the very inception stage is enough to render a fatal blow to the entire exercise undertaken. The term main grounds is not synonymous or interchangeable with the term allegations. There is no and there cannot be any ambiguity that main grounds is totally distinct and different from the allegation of being a foreigner. For avoidance of doubt, we may restate that this does not imply that strict proof of such allegation has to be given to the accused person, but the material on which such allegation is founded has to be shared with the person. For obvious reasons, and as pointed out herein before, at this stage, the question of evidentiary nature of the material and or its authenticity is not required. However, under the garb of and by taking recourse to Section 9 of the Act, the authority, or for that matter, the tribunal cannot give a go-by to the settled principles of natural justice, or the alteram partem does not merely envisage a fair and reasonable opportunity of being heard. In our opinion, it would encompass within itself the obligation to share material collected with the person accused concerned. It is no longer res integra that principles of natural justice need to be observed, even in statute is silent on that aspect, as laid down in Mongolian State of Madhya Pradesh 2004 to SCC so and so. Then paragraph 40 lordships. May I read that reference paragraph? Even if a statute is silent and there are no positive words in the Act, or the rules made thereunder, there could be nothing wrong in spelling out the need to hear the particular parties whose rights and interests are likely to be affected by the orders that may be passed, and making it a requirement to follow a fair procedure before taking a decision, unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute, unless there is a clear mandate to the contrary. No form or procedure should ever be permitted to exclude the presentation of a litigant's defense or stand, even in the absence of a provision in procedural law. Power inheres in every tribunal, court of a judicial or quasi-judicial character to adopt modalities necessary to achieve requirements of natural justice and fair play to ensure better and proper discharge of their duties. Procedure is mainly grounded on the principles of natural justice, irrespective of the extent of its application by express provision in that regard in a given situation. It has always been a cherished principle where the statute is silent about the observance of the principles of natural justice. Such statutory silence is taken to imply compliance with the principles of natural justice where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by express words of statute or necessary intendment. Its aim is to secure justice or to prevent miscarriage of justice. Principles of natural justice do not supplant the law but supplement it. These rules operate only in areas not covered by any law validly made. They are means to an end and not an end in themselves. Then paragraph 40, the initial infirmity of there being nothing on record as regards what grounds or material were actually available with the authorities to question the appellant's status as to his nationality is fatal to the projected case. The appellant had obtained documents, certificates from various officers with regard to his parents' continuous presence in India much prior to the date 25/3/1971, which were produced before the tribunal and have been noted by the tribunal in its report dated 16/11/17. Another relevant aspect is the prevalent situation on the ground where uniformed illiterate persons or persons not being well informed in the absence of any requirement to obtain and hold an official document and without possessing property in their own names would not have any official document issued by the government, state or central. It is neither difficult nor inconceivable to fathom such scenario amongst the rural populace, including within Assam. The evidence produced before the tribunal by the appellant to indicate that his parents had been resident in India much prior to 1/1/1966, whereas his siblings and he himself much prior to 25/3/1971, has been disbelieved only on the ground of mismatch of actual English spelling of the names and discrepancy in dates. As far as the discrepancy in dates and spellings are concerned, we are of the view that the same are minor in nature. Variation in name spelling is not a foreign phenomenon in preparation of the electoral roll. Further, the electoral roll has no acceptance in the eyes of law insofar as proof of date of birth is concerned. A casual entry by the enumerators when nothing had entering the names and dates of birth, so also the address of the persons, while making preparatory surveys for the purposes of preparing the electoral rolls cannot visit the appellant with dire consequences. Moreover, in our country, sometimes a title is prefixed or suffixed to a name such that the same person may be known also by one or two aliases. The tribunal seems to have been totally oblivious to all this. The state of Assam, as per the census 2011, boasts of 72%, 90% literacy rate with females and 60% females. So, however, this was not the case during the 1960s or even 1970s. Not just it in Assam, but in many states. It is seen that Names of people, even on important government documents, can have and do have varied spellings depending on them being in English or Hindi or Bangla or Assamese or any other language. For that matter, moreover, names of persons which are written either by the persons preparing the voter list or by the personnel making entries into different governments records, the spelling of the name based upon its pronunciation may make and slight variations. It is not uncommon throughout India that different spellings may be written in the regional vernacular language and English. Such same persons will have a differently spelled name in English and the local language. This is more pronounced where due to specific pronunciation habits or styles, there can be different spellings for the same name in different languages, be it English, Hindi, Urdu, Assamese, Bangla, etc. The appellant had produced a document showing that his father and mother had been resident of village Dulurpatar since 1965, that his siblings had also been declared not to be foreigners by the tribunal, and his elder brother and he were both voters as per the 1985 electoral rolls relating to 41 Bhavanipur Legislative Assembly constituency. Further, upon his marriage, the appellant came to village Kashipur in district Nalbari, Assam, where his name appeared in the electoral roll of 1997 for 61 Dharampur Legislative Assembly constituency. From an overall discussions on the report of the tribunal dated so and so, it is clear that there are minor discrepancy in the appellant's documents. However, their authenticity is not in doubt. In the considered opinion of this court, the same would further buttress the appellant's claim that to being in the wrong and being an ignorant person, she truthfully and faithfully produced the official records as they are in his possession. We do not see any attempt by the appellant to get his official records prepared meticulously without any discrepancy. The conduct of an illegal migrant would not be so trivial. The debate has long been settled that penal statutes must be construed strictly. Tularam, Relomol, the state of Bombay, so and so, at Para so and so, Nishika, so and so, so and so. Then lordships. Then paragraph page 49 lordships. After referring this paragraph, this if special provisions are made in derogation to the general right of citizen, the statute, in our opinion, should receive strict construction. The consequences which would befall the person declared as a foreigner are no doubt penal and severe. The moment a person is declared to be a foreigner, she is liable to be detained and deported to the country of his or her origin. Thus, the same would necessarily presuppose the existence of material to prove the person is not an Indian national and establish or identify his or country of origin. Here, on the facts, the authorities have not been able to succeed either on A or on B. Another possibility is that if the foreign country refuses to accept the foreigner, he would be rendered stateless and languish for the remainder of his life in confinement. Notably, under Constitution of India, Part 3, Fundamental Rights distinguishes between citizens and non-citizens. Articles 14, 20, 21, 22, 25, 27 are available to all persons. We have kept in mind Articles 14 and 21 of the Constitution while penning down this judgment. Then paragraph 50 lordships. Here, Sarvanda Sonal's case also mentioned lordships, 49 paragraph. Paragraph 50. Evidentially, our understanding that exposition of the law in the preceding paragraphs can be read with Sarvanda Sonal 1 Supra and Sarvanda Sonal 2 Supra. It embodies meaning as to what is expected of authorities till the stage of Section 9 of the Act arrives. The statutory burden would keep in thereafter. 5 learned judges of this court in Union of India, Bose Mahabod 961, SCC online so and so. That here stated this. Yes, then paragraph 51, Lordships. Regarding Ghosh Muhammad case reference, paragraph 6, page 57. Section 9 of this act is the one that is relevant. That section, so as far as its material is in this term. It is quite clear that this section applies to the present case, and the onus of showing that he is not a foreigner was upon the respondent. The High Court entirely overlooked the provisions of this section and misdirected itself as to the question that arose for this one. It does not seem to have realized that the burden of proving that he was not a foreigner was on the respondent and appears to have placed that burden on the union. This was a wholly wrong approach to the question. However, the above conclusion was premised on what the court noted in the preceding paragraph in Ghosh Muhammad. So the High Court observed that there must be prima facie material on the basis of which the statutory can proceed to pass an order under Section 3(2)(c) of the Foreigners Act 1946. No doubt, if there exists such a material and then the order is made, which is on the face of it a valid order, then this court cannot go into the question whether or not a particular person is a foreigner or, in other words, not a citizen of this country, because according to Section 9 of the Citizenship Act 1955, this question is to be decided by a prescribed authority, and under the Citizenship Rules 1956, that authority is the central government. The High Court then examined the materials before it and held in the present case there was no material at all on the basis of which the proper authority could proceed to issue an order under Section 3(2)(c) of the Foreigners Act 1946. In this view of the matter, the High Court quashed the order. We need not to be detained in Ghosh Muhammad's reply, as it is clear that therein the Punjab High Court Circuit Bench at Delhi had conflated the Act within the Citizenship Act. Fateh Muhammad versus Delhi Administration 1963, supplementary 2 so and so. 4 judges bench and Masood Khan versus State of Uttar Pradesh 1973 SCC so and so followed Ghosh Muhammad. We are of the opinion that facts therein were also different than what stares us in the case at hand. No doubt the principles of law stand, yet we see no real difficulty in our formulations herein above, harmonizing with what has been held in the gamut of case law. As such, the burden under Section 9 of the Act would operate in the manner delineated by us, factoring in the imperative to maintain consistency amongst Ghosh Muhammad Supra, Sarvanda Sonal 1 Supra, Sarvanda Sonal 2 Supra, Mukesh Singh Supra, and this judgment. For and on the strength of the totality of reasons effort indicated, this court finds that the report opinion of the tribunal dated 16/11/17 as sought by this court through order dated so and so is wholly unsustainable. According to the report opinion dated so and so is quashed, as the report opinion dated so and so has been examined threadbare by us. We have no hesitation in setting aside the tribunal's order dated so and so, as also the impugned judgment dated so and so passed by the High Court. In any event, once this court had passed the order dated so and so Supra, calling for a fresh report opinion, thus sequitur would translate into the tribunal's order dated so and the impugned judgment becoming susceptible in being quashed. It is suitable. And this court has found that the intervention drawn by tribunal do not falsify the appellant's claim. In view of the detailed analysis, the discrepancy in the material produced by the appellant can be termed minor, save when not sufficient to lead to tribunal to doubt the disbelief the appellant and version put forth in. Here the inclined to remand the matter to tribunal for another round of resolution, putting authorities quitus to issue, the appellant is declared innocent. Here is the case exactly similar, lordship. No materials, there is no material at all, lordships. And my evidence also not been refuted. In this regard, I am relying upon the decisions of this, our High Court lordships, Matur Rahman, that is reported 2021 GLT 330 regarding uncontroverted evidence lordships. Lordships. I am sorry, one more. Tiur Rahman case lordships only one extra copy, only one lordships. 2 copies only I have lordships. One with me. And Abdul Khalik in Motiur Rahman case lordship, I am sorry, 1 copy I have provided lordships. 1 copy I have lost lordships. Paragraph 8, 9, 11, 12. Paragraph 8. In Motiur Rahman lordship that is reported in 2021 GLT, page 330. Paragraph 8, may I read lordships? In this case, the petitioner has produced the voter list of 1966 of number so-and-so West Gwalpara LSC, where the names of his father, Ahmed Ali, and mother, Foirajan Bibi, was included. Certified copy of the electoral roll of 66 available on record as Exhibit A. Respondents have not disputed the correctness of Exhibit A. The petitioner has also produced certified copy of the electoral rolls of 1989, wherein the name of the petitioner has been entered as son of Ahmed Ali. There is nothing on record to dispute the claim that the petitioner is the son of Ahmed Ali and Foirajan Bibi, who are living in India since prior to 1966. Mr. Payang has also submitted in his usual fairness that the respondents are not questioning. Yes. Lordships. In paragraph 9 lordships, paragraph 8 was reading lordships and so. As mentioned above, the DW2 lordships.
We'll have to rise early. You'll have to just give the paragraphs of this,
8, 9.
this, what do you call, Motiur Rahman,
Motiur Rahman, paragraph 8 and 9.
8 and 9.
9. And Abdul Khalik lordships.
Just a moment. Abdul Khalik.
Abdul Khalik, paragraph 9 and 10.
That's true.
Lordships. Here, evidence also not only death discrepancies, fathers, siblings or not, but other things are not denied, not questioned that he is not my father, she is not my mother. Other families not denied lordship. The state also not questioned. On that ground, lordship can tribunal declare the petition as foreign lordships. That only fathers and siblings has or not. Other things are correct, not disputed also tribunal. Other opposite party also not questioned also, that she is the so person's daughter or not.
We have to rise for division bench. We'll hear you next week. Be prepared on these citations which have been given and make a response. The submissions from Mr. F. Barbuya and counsel for the petitioner remains is concluded, reserving right to reply. Due to paucity of time, the respondent side could not be heard. You just record the presence, Mr. G. Sharma, Mr. H.K. Hazarika, and Mr. A.K. Datta. CGC, A.K. Datta. Their part could not be heard. Next list on. Get it on Monday or Wednesday? Wednesday. List on 14/8/2024. So you have fought back. Yes.
Single bench, item 1.
Part of council is being senior, senior lordship matter may be taken up from.
Oh, acha. Okay. Did to कितने दिवो?
Sir, 22 তারিখ বাদ দি দিব পাৰি 22
আৰু এইটো কেতিয়া আছে আমাৰ
বচপন বচাও 22/8 আছে আৰু এইটো 19 আজি দিছিলো ডেট
19
sir 19/8 22/8 আৰু 19/8 বাদ দি দিব পাৰি
so fixing 27/8 then. But please see that the matter is heard on that day. Both sides are represented. The learned counsel for the respondent has submitted a adjournment slip on 7/8/2024. Oh, sorry, 8/8/2024. Expressing inability to do the matter today. Your name is H. Barua, learned counsel appearing on behalf of the learned counsel for the applicant. It will be applicant, huh? Has also prayed for an adjournment. That's right. Prayer is allowed. List on 27/8/2024. 8/8 कुछ नहीं content 8/8 nothing 8/8 adjournment slip is 8/8 okay